We are live.
All right, Cindy, so we are live and ready to go?
Yes.
Okay, great. Well, good afternoon or good morning, everyone. Welcome to the Judicial Proceedings Committee. Today is Wednesday, January 27th, 2021. We have 10 bills on the docket today. So I'll start off with the order. The Trust Act is number 1. So Senate Bill 88 is number 1. Senate Bill 253 is 2. Our third bill of the day is Senator Benson with Senate Bill 297. Fourth is 315. Fifth is 337. Sixth is 179. Seventh is 317. Eighth is Senate Bill 75. Ninth is Senate Bill 20. And we'll round out the day with Senator Wallstreicher, Senate Bill 293. So with that, I will start off with Senate Bill 88. I think all of our witnesses are here and we are ready to go. So without further ado, I'll just go ahead and start. So good afternoon, committee members. Senator Will Smith here to present Senate Bill 88, which is the Trust Act. Obviously, our committee has wrestled with this issue every year that I've been in the Senate. And our committee has actually passed several portions of the bill that you have before you today. But in my opinion, we've never taken the most critical or the most critically important steps that are contained within the bill, which I'll highlight in just a moment. But before I get into the mechanics of the bill, I'd like to take a moment to talk about why this bill is so important and why it's important that we move on this bill today and during this legislative session. Not only is this bill, or passage of this bill will take us to a more humane society, but it'll also make us ultimately more safe. It'll make our communities a safer place to thrive and to live. Again, I'd like to reemphasize that this proposal is about making our communities safer places to live and thrive. Now, I've served in the Department of Homeland Security as an appointee under the President Obama administration. I've also served in uniform overseas, and I have the highest regard and respect for the brave men and women in law enforcement. In short, I would never put a piece of legislation forward that I thought would jeopardize the safety and well-being of every Marylander, Marylanders that I've spent my entire life serving in public service. But here's the reality. Far too many immigrants feel unsafe getting the help that they need when they need it. They're afraid to call the police during an emergency. They're afraid to show up to court to testify against an abuser. They're afraid to participate meaningfully in any investigation. Some of our research that you've seen before, but that I've done again for this hearing, one, I'll just cite a couple statistics from a study from 2019. Immigration and domestic violence advocates and lawyers revealed that 76% of the advocates and lawyers report that their immigrant clients are afraid of contacting law enforcement. 52% of advocates and lawyers worked with immigrants and survivors, and they dropped their cases because they were afraid of the consequences for themselves or for their families. And I'll just read a few excerpts from the report from a couple of the attorneys. One gentleman said that many victims are afraid that they will be deported when they report their domestic abuse or sexual assault. They are fearful that any contact with law enforcement puts them in a more dangerous position than just staying silent. Another woman said that survivors are afraid that they will be reported to Immigration and Customs Enforcement and will be removed from their children. Now, this has happened on numerous occasions in our community, and it continues to happen. Some of the more Maryland-specific examples. Now, obviously, in Maryland, we have 3 jurisdictions, Cecil, Frederick, and Harford counties that have established the 287G program, which I'm sure we'll get into more detail later on. The program, the studies have shown, and the numbers which we'll discuss a little bit later, has in far too many cases targeted people that have been in this country for years, people who have paid taxes, started families, and who have enriched our state with talent, labor, and enterprise. The program also provides opportunity for racial profiling. For instance, a Frederick County woman was pulled over for a broken taillight that was actually not broken and is now under supervision. A woman who testified in favor of this bill in 2020, just last year, has had to do ICE check-ins in Baltimore since 2014. And those check-ins have been more frequent in the past years, including 3 in 2019. Every time she goes, she reports to us that she's afraid that she's going to be deported. A woman named Claudia, who testified in 2020, was rear-ended in February of 2019. She was the victim of a car accident. When she filed a police report, her documents were taken and she was detained by ICE. She was released within a day, but she still has to do ICE check-ins, and she's often afraid of being deported and being separated from her 3 young children in our community. Another man who testified in 2020 was cutting down a tree as a favor for his uncle. When DNR showed up, they asked him for a permit, which he didn't know he needed. They asked for his license, they ran a background check, and they detained him. He is now on supervision as well. Some of the more revealing statistics. In Frederick County, more than 80% of the 287G arrests were for low-level offenses, and more than 60% were for traffic offenses. So that's why we need this bill. And as our friend and former chair of the House Judiciary Committee would say, on the bill. So on the merits and the mechanics of the bill. I'll just read some of go over some of the wave tops, because as you see, it's a lengthy bill, and I'm sure we're going to get into a more in-depth and detailed conversation about the specifics. But I want to highlight some of the wave tops, the important wave tops, and I'll direct you to the page numbers and even the line numbers where you can kind of follow along. First, it creates a prohibition. It's a prohibition on the creation of a registry for the purpose of discriminating against a person on the basis of their race, religion, immigration status, etc. That can be found on page 2 and 3. Second, the bill expresses the intent of the Maryland General Assembly to maintain a level of trust between law enforcement and our immigrant community. It's on page 4. Third, there's what I call the no show me your papers provision, kind of like what they had in Arizona with under the governor, Jan Gardner. This prohibits law enforcement from inquiring about a person's immigration status during a stop, search, or arrest. That's also on page 4. Fourth, it prohibits detaining an individual for the sole purpose of investigating or inquiring about their immigration status. That's also on page 4. Fifth, prohibits coordination with federal authorities relating to the enforcement of civil immigration. That's page 6. That's in lines 6 and 7. And this includes access. So we'll address the judiciary's opposition, but that includes access to certain government facilities. Sixth, an outright prohibition and involvement in the 287G program, which is on page 7. Seventh, it permits the use of foreign passports issued by a foreign government, also documents issued by an embassy or a consulate, or any other valid ID that's issued by a foreign government that could be used during a stop or a potential arrest. Seventh, notification. So to the extent practicable, our government would have to notify if there's been a request for immigration information from the federal government, who have to notify the individual that's subject to that request. And then finally, the AG guidance, which is uncodified language that can be found on page 10, that talks about developing a set of guidelines and criteria to maintain safe spaces so that our immigrant community can feel safe accessing public facilities and public resources in our state and our counties. What the bill does not do, it does not prevent coordination with federal authorities in criminal cases or in cases in which involve national security. It doesn't prevent an immigrant from being arrested, tried, or charged for a crime that they commit. It does not prevent law enforcement from collaborating with ICE if the immigrant has committed a criminal charge, like sex trafficking, some of the opposition testimony highlights. It does not prevent law enforcement officers from requiring a warrant from any circuit court judge at any hour of any day in any case of suspected criminal conduct. So in conclusion, Senate Bill 88 would make the Trust Act a statewide standard, which would build on the progress that we've already seen in Prince George's, Montgomery County, Baltimore County, and Anne Arundel counties. I go back to what one of our regional partners and neighbors has said. The Attorney General in New Jersey issued a number of these same directives. I mean, he issued a number of these same initiatives in a directive. It wasn't a piece of legislation, it was a directive issued by the Attorney General. And some of the quotes I think are relevant to when he released this. He said that nothing in this directive, and in this case, our law, offers sanctuary to lawbreakers, and nothing hampers police from complying with federal law or valid court orders, including judicial arrest warrants. Now, the Camden County Police Chief, in response to what the Attorney General's directive would do, said that police officers are charged with the care and safety of all members of the community, regardless of their immigration status. That was from the Camden County Police Chief. I think that their example, because it's the most recent that I could find, is instructive. Their community cooperation, the security proposition of their state, and the overall security and livelihood of their state has increased as a result of these new initiatives being put on the books. So with that, I would respectfully request that this committee issue a favorable report for Senate Bill 88. And before we get into it, I'll be here to take detailed questions, but I want to open it up to our panel first, and then I'll be here to take questions, as I'm sure they're sure to come from several members of our committee. So first up, we have Mr. Katz. You are up first.
Thank you, Chair Smith and members of the committee. My name is Nicholas Katz. I'm the legal director at CASA de Maryland. CASA is the largest membership-based immigrant rights organization in the Mid-Atlantic region, with more than 90,000 members here in Maryland and over 100,000 across Maryland, Virginia, and Pennsylvania. Thank you for this opportunity to testify today in support of SB 88, known as the Trust Act. As Chair Smith very eloquently outlined, this bill has a simple purpose: to ensure that immigrant Marylanders feel safe going to work, accessing services, calling the police, or otherwise engaging in everyday activities without fear of being put into the deportation system. For the last 8 years, the Trust Act has been the top priority of CASA's membership, as they've continued to see their family and their communities torn apart by a broken immigration system with the unnecessary collaboration of our state. This must end. As CASA's legal director, each year my team sees hundreds of Maryland residents who come to us seeking advice about their immigration situation. The majority of these have been impacted by the immigration detention system on some level, and almost none of them have ever had the opportunity to talk to a lawyer. A little bit later, you'll hear testimony from one of our members who Chair Smith mentioned, who was the victim of a minor car accident and instead of getting help, was put into the deportation system. Sadly, this is not an isolated case. In Baltimore, another CASA member had an emergency with her car where it lit on fire, and a tow truck driver came and he called the police, despite the pleas from our member for him not to do that, because she knew the risk of engaging in an interaction with law enforcement. Sadly, the worst happened and the police came and transferred her to ICE, and she was deported to El Salvador, where she continues to advocate, even from outside of the country, for an end to this system that puts other people at risk, so that what happened to her won't happen to others. Chair Smith also mentioned the case of Jose Vialta, a CASA member who was trying to help his family trim a tree and was picked up by the Department of Natural Resources Police and transferred to ICE custody. Even though he was doing this within a jurisdiction that had already passed a trust policy in Montgomery County, he was helpless because it was state police that was interacting with him. And he continues to fight his deportation to this day. Jose has lived in the United States for 15 years since he was a teenager. He contributes to our community. He is a hardworking member of our society and a Marylander who cares deeply about his state. He should not be fighting his removal because of his interaction with state police. More than a dozen jurisdictions in Maryland have already passed similar trust policies, including Prince George's, Montgomery, Baltimore City, and others. But these are not enough. They don't protect members from state police. They don't protect our members from traveling across county lines to work or to see their family. They don't stop jurisdictions from entering into these voluntary agreements to help with the deportation machine that ICE runs. Only you can do that through this bill. You'll hear arguments from the other side that this bill will allow violent criminals to go free. It will not. SB 88 does nothing to alter our criminal justice system. If someone's committed a crime, they can be arrested, detained, and prosecuted for it. If federal agents have a warrant, they can receive a transfer of an individual who's in custody. What this bill does is completely and affirmatively separate our state from voluntarily collaborating in the enforcement of civil immigration law, which is entirely the responsibility of federal government. In fact, the current system of collaboration undermines Maryland's criminal justice system. Individuals who are put into ICE custody routinely aren't presented for their criminal trials, denying them the opportunity to contest their innocence and denying victims the opportunity to get justice. At CASA, we constantly hear from people like Nora, the member whose car was on fire, who are desperately afraid to even contact the police because what they know might happen next. We have to stop this. We have to instill trust in the community. The other side may also say we should exempt out certain categories of people, the really bad criminals, who we should want to send over to ICE custody. But the reality is we have the criminal justice system to deal with these individuals, and there's nothing that prevents that from happening. When you create space to separate out certain types of individuals or certain groups of individuals who we consider to be undesirable, that creates space for abuse by law enforcement, and it undermines the purpose of this bill, which is to establish trust with the community. We've seen over the past 4 years some of the worst attacks against immigrant communities in our country's history. These wounds run deep and they will not heal quickly. Even under a more favorable federal administration, ICE will continue to perform its essential function to remove people from the community permanently, deport them outside the United States. Unfortunately, we can't stop ICE from engaging in this activity. We can't change federal immigration law, but we can stop our state from collaborating. Thank you, Chair, for this time. In summary, CASA strongly supports SB 88, and I look forward to answering your questions.
Excellent. Thank you, Mr. Katz. Next, we will have Ms. Ramos Ardon. You're ready to go whenever you're ready to proceed.
I'll be translating for Claudia. Okay, Claudia.
We've got you both. Great.
Tenga muy buenos días, estimado presidente Smith y miembros del comité.
Good afternoon, Chairman Smith and members of the Judicial Proceedings Committee.
Mi nombre es Claudia Ramos.
My name is Claudia Ramos.
Y estoy aquí para pedirles su apoyo para la SB 88.
I'm here to ask for your support in passing the bill SB 88.
Y apoyen a familias como la mía.
And to support families like mine.
Hace casi como 2 años, en febrero del 2019.
Almost 2 years ago in February 2019.
Estaba llevando a mi hijo pequeño a la guardería.
I was driving my young child to daycare in Hyattsville.
Y después a mis otros 2 niños a la escuela.
And my other 2 children in the car were with me as well.
Cuando iba hacia la escuela, llevaba mis 2 hijos conmigo.
I was also taking my kids as well. Ya dice eso, okay.
Y tuve un accidente.
I had an accident.
Que no fue mi culpa. Fui chocada por atrás.
It wasn't my fault. I was rear-ended.
Y fue un accidente de 3 carros. Otro me le pegó al otro y el otro. Fueron 3 carros involucrados.
There was 3 cars involved. Because of the previous car, it hit my car.
Mi carro tuvo pocos daños, casi nada.
My car was barely damaged.
Pero tenía que esperar hasta que llegara la policía antes de irme.
But I had to stay until the police arrived before leaving.
Cuando llegó la policía, tomó toda nuestra información.
When the police arrived, they took all of our information.
Pero me quedé sorprendida cuando el policía
but I was surprised when the police
permitió que se fueran los demás carros involucrados, pero no yo.
But when the police allowed the other cars to leave, but not my car.
A pesar de que los otros carros estaban en peores condiciones.
Despite that the other cars were in worse condition.
La policía me retuvo allí durante 1 hora y media.
Police helped me for over an hour.
Y apareció ICE.
And ICE showed up.
Después de yo ser víctima del accidente.
After being a victim of a car accident.
La policía, en vez de ayudarme, llamó a ICE.
The police, instead of helping me, they called ICE.
Ellos me esposaron y me llevaron a Baltimore.
ICE handcuffed me and drove me to Baltimore,
Estuve detenida durante todo el día.
where I was detained for the whole day.
Todo lo que yo podía pensar era en mis hijos.
And all I can think about was my kids.
Vivo aquí con mi familia desde el 2005.
I've been living here with my family since 2005.
Para mis hijos, ellos nacieron acá, solo acá conocen, no hay un futuro en El Salvador para ellos.
My kids were born here. My kids only know here, and so there's no future for my family in El Salvador.
Aquí es nuestra casa.
Here is our home.
Aunque fui liberada de la custodia de ICE,
Although I was released from ICE custody,
todavía estoy luchando contra mi caso de deportación.
I'm still fighting my deportation case to this day.
Hasta el día de hoy. Ahí estoy chequeándome con ICE cuando ellos me lo piden.
I go to my ICE check-ins when I'm requested to come in.
Trabajo en limpieza
I work as a housekeeper.
y he gastado lo que yo tenía ahorrado para pagar mi abogado.
And I spent every bit of my savings paying for my lawyer
Para poder detener mi deportación.
to help stop my deportation.
Estoy muy nerviosa por lo que pueda pasarme.
I'm very nervous about what will happen.
Esta experiencia con la policía no solo me ha traumatizado a mí, sino también a mis hijos.
This experience with the police has not only traumatized me, but has also traumatized my children.
Yo estaba tan feliz el año pasado cuando el Consejo del Condado de Prince George aprobaron su versión de la ley de confianza.
I was happy that last year, the Prince George's County Council unanimously passed their version of the Trust Act.
Para que historias como la mía ya no puedan suceder y no pase nadie por lo que yo estoy pasando.
So that stories like mine won't happen again and another family won't go through this experience.
Pero para que podamos realmente confiar en la policía,
but in order for us to truly be able to trust the police,
deben aprobar el proyecto de ley en todo el estado de Maryland.
we need to pass this bill in all of Maryland.
Sigo compartiendo mi historia
I continue to share my story
para que lo que me pasa a mí no le pase a otros.
so that what happened to me will not happen to others.
Legisladores,
Legislators,
ustedes tienen el poder para poner fin a esta separación familiar.
you have the power to put an end to this family separation.
Espero de todo corazón que consideren mi historia
I hope with all of my heart that you consider my story
y aprueben la ley SB 88.
and to pass the SB 88.
Gracias.
Thank you.
Thank you very much, Ms. Ramos, for taking your time to testify and be here with us today. Next, we will go on to Mr. Alston.
Good morning, Chairman and members of the Judicial Proceedings Committee. I am Linwood Alston, the Interim Chief of Police for the City of Mount Rainier, Maryland, and Prince George's County. I'm here in support of SB 88. The City of Mount Rainier is the most densely populated city in the state of Maryland and ranks 79th in the nation in population density. Our beautiful community is also a very diverse one. It is my job to ensure that the safety and public order for all residents. Also, it's my responsibility to create and strengthen relationships between police officers and the community. It has been our main focus to build trust and legitimacy with all members of our diverse community. At all times, treating residents with dignity and respect, However, it's difficult to advance those goals with a significant population of my community is scared to talk to the police. The national discussion on immigration has real implications at the local level that only exacerbate existing local challenges. As a local department, we're less efficient if residents don't trust us enough to report crimes or even help us solve them. As a way to counter the fear of our immigrant community, the city of Mount Rainier has adopted a welcoming ordinance, Chapter 1E, Immigrations and Customs Enforcement, which many of the critical provisions of SB 88 are listed in that. Some of the critical provisions are codifying that local law enforcement does not engage in immigration enforcement. Law enforcement officers are not interested in your immigration status, and clearly states that immigration enforcement is solely a federal responsibility. Equally important, our local ordinance send a strong message to our immigrant community that our police department is focused on ensuring public safety for all of our residents, regardless of immigration status. We are fortunate to have police officers on our staff that are a part of the a part of our immigrant community. They do a lot to help improve our community relations. Our immigrant community feels comfortable in trusting and relating to officers that look like them. Lastly, SB 88 will not prohibit police from fulfilling our duties. In contrary, SB 88 will be a tool in our community policing toolbox. I respectfully urge the passing of SB 88. Thank you.
Thank you, Chief. Next, we'll have Mr. Mohammed. Ready to go.
Thank you, Mr. Chairman and Senate Judicial Proceeding Committee members. My name is Zaifa Mohammed. I'm the Government Affairs Intern for the Council on American Islamic Relations. On behalf of the Council on American Islamic Relations, I want to thank you for this opportunity to testify in support of Senate Bill 88, entitled State and Local Government Participation in Federal Immigration Enforcement. I just want to thank you guys for your leadership on this issue. CARE is America's largest Muslim civil rights and advocacy organization. Its mission is to enhance the understanding of Islam, protect civil rights, promote justice, and empower American Muslims. The United States' immigration detention program, operated by Immigration and Customs Enforcement, is the largest of its kind in the world. Individuals in the ICE detention center are deprived of basic liberty, access to a lawyer, and access to loved ones. According to the Cato Institute, 21 people have died while in ICE custody in 2020 alone. ICE detention facilities endanger lives and reinforce a system of oppression counter to the democratic principles in our country. ICE has contracts with many local governments that it uses to operate its detention centers, including 3 here in Maryland, in Howard, Frederick, and Worcester counties. This bill would signal to immigration authorities that our state does not support their inhumane policies. Prohibiting state agencies from enforcing federal immigration laws would inspire trust in law enforcement, help improve public safety for families across Maryland by improving reporting of crimes, and encourage vulnerable families to apply for social services. Passing this measure would send a clear message that the state of Maryland chooses to stand on the right side of history. On behalf of the Council on American Islamic Relations and the communities that I serve, I respectfully urge a favorable report on Senate Bill 88. Thank you for your consideration.
All right, thank you very much. That concludes the testimony for the proponents. We'll now switch over to the opposition panel. And first up, we have Sheriff Geller of Harford County Sheriff's Office. Sheriff, the floor is yours.
Thank you, Senator Smith. Can you hear me okay? Thank
Loud
you.
and clear. Yep. Loud and clear.
Okay, thank you, Mr. Chairman, members of the Senate Judicial Proceedings Committee. I have submitted written testimony that you should have. And in hearing some of the introductory comments, I do find myself in a position of opposition to the bill this morning, and particularly related to our participation in the 287G program. I've been down in past years and testified in front of the committee. We were actually accepted into the 287G program by President Obama and Vice President Biden's administration back in 2015. It is a program that has first implemented by President Clinton and has survived every administration with some changes along the way based on the priorities of the different administrations. With a new presidential administration, that of President Biden, I think we'll again see a change in priorities, but it is clear from communication that we've already received that they will be prioritizing threats to national security, public safety, and border security for immigrations and customs enforcement. And I've heard on this testimony this morning, law enforcement and the stories, the different incidents involving some of those people who have testified, and all being law enforcement based, and the chief who just testified, thank him for his service. But everything is law enforcement. 287G program at one time had a law enforcement component. It does not any longer. It's strictly corrections based. It does not impact the Harford County Sheriff's Office's law enforcement operations, how we respond to citizens on the road or calls for service. And when we first implemented the program, we actually sat down with LASSOS, which is our Harford County advocacy organization for the immigrant community, and got their support when the program was explained to them. And again, simply, if anyone is arrested in Harford County for anything not related to immigration, but they're arrested for something that's a violation of law, and it can be traffic, as Senator Smith noted, DUI or similar serious traffic charge gets you brought to the detention center. At that point, you are screened through the MOA, the Memorandum of Agreement. You are screened by our deputies to see if you're in the country legally, and if not, if you're not in the country legally, then that can be reported to Immigrations and Customs Enforcement through our Memorandum of Understanding, and they can decide based on their priorities, based on this presidential administration's priorities, what actions they see appropriate to take in the interests, again, of national security, public safety, or border security, what priorities they want to take to keep our communities safe. So I think it gets confused a lot with the law enforcement. And again, 287G had a law enforcement component at one time. It does not any longer. But I would like to see, I stand in opposition again today as related to the 287G partnership that we enjoy here, which I think keeps our community more safe. We've had the lowest, we ended last year with the lowest crime numbers Harford County has ever seen. So I do stand in opposition to the bill today, Senator Smith.
All right, excellent. Thank you very much. Good to see you.
Yes, sir.
Now we'll move on to Sheriff Jenkins from Frederick County. Sheriff, you're up. Yeah, I have to unmute you here. Sheriff Jenkins, hold on one second. I think you have to unmute yourself.
I should be unmuted.
There you go.
Okay. Good morning, Mr. Chairman. Good to be here speaking in front of the group this morning. Committee members, again, Charles Jenkins, Sheriff Frederick County, here in regard to concerns for public safety. Listen, we have been a member of the 287G partnership since 2008. It is strictly a jail program. Nothing happens outside of the confines of the jail facility. It's a legal, lawful program that allows sheriffs and other local governments to enter. I think that choice to participate should be left to local governments or local sheriffs. The program, again, I can't emphasize enough, the program is solely within the confines of a jail. It's a corrections-based program. And a lot of the things, Senator, all due respect, that you talked about in your opening remarks that have occurred in Frederick County are mischaracterized. I certainly don't have the time to get into that. Since 2008, this program has been very effective, removing 1,582 criminals from our streets, placing them in removal proceedings. 111 of those were validated criminal gang members, mostly affiliated with MS-13. 42 others came here as unaccompanied juveniles, grew up to commit felonies, and were gang members. This program has kept our streets safer. And again, I would argue, as you see across the country, almost every day in this country, Americans are victims of crimes committed by illegal aliens. Other considerations for opposing this bill, the bill would eliminate the reimbursement from the State Criminal Alien Assistance Program called SCAP. Frederick County has received $226,000 since 2015 Other counties have received far more in reimbursement. We currently have the Intergovernmental Services Agreement in Frederick. We've been reimbursed $16 million plus since 2008. Those funds are placed back into the county's general fund, used by the county as they see fit, and some of those funds have even gone to a local nursing home, county-owned nursing home. In order to process arrestees in central booking, you must ask the subject their country of citizenship. NCIC will not accept fingerprints without that. In order to properly protect the staff and inmates from a jail. And COVID-19 is the best example of this. We have to know where they're from. This COVID-19 crisis is the very best example of why we need to ask that question and get that critical information. Passing this legislation will place our Maryland counties and communities at risk of increasing serious gang crime, more overall crime, less safe schools, and will be a very costly burden for Marylanders. I think this bill is totally unfair to every Marylander and every United States citizen, totally ignoring the rule of law to which our Constitution relies on to maintain civil order. And again, I stand by this. Not one American citizen and not one Marylander should ever be the victim of a crime committed by an illegal alien. One of your primary responsibilities as lawmakers in this committee is to assure the best public safety possible. Please don't ignore that for the sake of your own families. As Sheriff of Frederick County, I stand with sheriffs and chiefs across the state in opposition to this, and I respectfully ask and urge this committee for an unfavorable report.
All right, thank you for that, Sheriff. Next, we will go on to Ms. Rendell. There you are.
Thank you, Chairman Smith and other distinguished members of the committee. My name is Sherry Rendell, and I am the Director of State and Local Engagement at the Federation for American Immigration Reform. FAIR is a nonprofit, nonpartisan organization that believes our immigration laws must be reformed to serve our nation's interests. We have 3 million members nationwide and approximately 12,300 in Maryland. And I am here to oppose SB 88. Sanctuary policies place a greater emphasis on the welfare of illegal aliens than the well-being of citizens and legal immigrants in their own communities by impeding the enforcement of federal immigration laws and blocking free communication between local officials and federal immigration officials. You mentioned in your opening remarks, Chairman, that the bill will make Marylanders safer. After Montgomery County expanded its sanctuary policies, it experienced an illegal alien crime wave that was directly tied to the sanctuary policies. In just over a month, 8 illegal aliens were charged with committing sex crimes in the county. This is also similar to what's happened in California. After California's sanctuary law was enacted, Orange County, 2 years after, had to release 1,500 aliens with ICE detainers back onto their streets. More than 400 of those aliens were rearrested with charges including rape, assault with a deadly weapon, child sex offenses, and domestic violence offenses. Every single one of those crimes was preventable. None of those criminals should have been back on the streets in California. Additionally, SB 88 conflicts with federal law. Specifically, Title 8 USC 1357 G10 states that formal agreements with federal government is not necessary for any officer or employee of a state or local agency to communicate regarding immigration status of an individual, including reporting knowledge that an alien is not lawfully present in the United States, or to help the Attorney General in the identification, apprehension, detention, or removals of criminal aliens. There are nearly 3 million criminal aliens in the United States. Thank you.
Okay, thank you, Ms. Rendell. Finally, we'll have Mr. Botwin. You're up next. There you go.
There we go. Thank you. My name is Brad Botwin, and I'm the director of HelpSaveMaryland.org. I'm here today to express my serious concerns with SB 88, a politically motivated bill promoting Maryland State Sanctuary. This is the 8th time since 2014 that this elected body has subjected the citizens of Maryland to this unnecessary and have implemented quite dangerous legislation. Specifically, SB 88 will interfere with federal law enforcement actions to remove illegal alien criminals from our jails, schools, hospitals, courthouses, and most importantly, our communities. It will require Maryland counties, Frederick, Cecil, Harford, that are partnered with federal ICE to end their successful force multiplier law enforcement cooperation. SB 88 contains much more. We as taxpaying citizens are at a loss as to how passage of this bill will enhance public health and safety and the quality of life for all Maryland residents. Sanctuary jurisdictions endanger law-abiding citizens and legal immigrants who are subject to increased levels of crime, murder, rape, drugs, prostitution, and MS-13 gang violence by brazen, often repeat offenders abusing their sanctuary status. My own Montgomery is a perfect example of sanctuary policy gone wrong. In 2019, there were hundreds of sexual assaults and rapes in the county, many committed by illegal aliens. The committee is well aware of the carnage that took place that summer when 12 young girls, 15 and under, were assaulted and raped by these law-breaking aliens. Our citizens fought back. Are the members of this committee prepared for the same horrible outcomes and the same citizen protests and more from your constituents? Even now, citizens in Howard County are rising up against the sanctuary that was recently forced upon them by their enlightened politicians. Finally, I am shocked that legislators representing Maryland's Black communities readily co-sponsor toxic legislation like SB 88. The brunt of the crime, decline in public schools, social services, healthcare, and the loss of employment opportunities falls most heavily on your Black and legal Hispanic constituents. The SB 88 amnesty and sanctuary are not priorities for Marylanders dealing with COVID-19 and high unemployment. Thank you.
All right, thank you very much. Lots to unpack there. I suppose if the Biden administration succeeds in removing alien from the code, you guys will be forced to stop using that word. I suppose that Mr. Botwin, being a Black person, obviously that was interesting commentary from you. Okay, it looks like we have Senator Lee has a question.
Okay. Can you hear me now, Mr. Chairman?
There you go.
Okay. Thank you, Mr. Chairman. This question is for Sheriff Geller of Harford County. My understanding of SB 88 is intended to help increase trust and cooperation between law enforcement and our immigrant communities to help work together to solve crimes and keep us, families and communities safe, so that we can all, be able to walk down streets, as you said. But in 2017, I think it was your department that was involved in stopping an American woman of Indian descent and stopping and detaining her. Isn't SB 88 intended to kind of address this issue?
Thank you for the question, Senator. Can you hear me okay? No, it was not the Harford County Sheriff's Office that was involved in that. It was actually the Bel Air Police Department, and it's just not my agency. I'm not privy to all the details, only the newspaper articles, and I'm not going to say that they're 100% factually correct, so I'm not going to speculate on what led to that encounter. But back to the testimony, this has the 287 from the 287G perspective. And that's what my main interest on Senate Bill 88 has to do with. It is strictly a corrections-based program. In fact, the gentleman who just testified in opposition to the bill, I'm sorry, I didn't write down the name, but he even said that it is a cooperative agreement between law enforcement and federal partners. It's not, at one time it had that component. It is strictly a corrections-based program. Corrections and law enforcement cannot cross over. So even though they both fall to the sheriff's responsibilities, many counties have their own Department of Corrections and a police department. In Hartford, in Frederick, and in Cecil, the sheriff has those responsibilities, but a correctional deputy cannot go out in the community and police. And a law enforcement deputy can't go into the jail and do the corrections agreement under our memorandum of understanding with ICE and be trained to work in this program. So no one in the street from the Hartford County Sheriff's Office is trying to enforce civilian immigration enforcement to do that job. Only at the point of screening, when you come into the jail, when you've been arrested for something else, are you screened to see who you are, fingerprints, photographs, as we've always done, and if you're in the country illegally. And again, that doesn't mean you're going to be deported. It just means if you are here in the country illegally and have committed a crime, then that will be reported to ICE. And based on their priorities and this new presidential administration's priorities, they could decide up to deportation what action to take. I hope I was able to answer your question.
Senator Lee.
My question now is for Mr. Katz. You think that it's truly the case? You've actually incidences of, we're concerned about violations of civil rights and also to create safer communities by the better cooperation and trust between law enforcement and our communities. And we just want to, I think that this is the legislation that is intended to achieve that purpose.
Thank you, Senator. And I think at CASA, we completely agree. I mean, I think regardless of, the framing of a corrections program or law enforcement program, the perception from our members is that there's a collaboration between law enforcement and immigration, and that reality exists. And we've seen civil rights abuses stemming from these partnerships, even though they may supposedly be restricted to jails or certain categories of individuals, violations of that occur, right? And so I think SB 88 is what we need in order to make the policy clear and uniform across the state and make our members feel comfortable doing all the things that you mentioned, just living their daily lives and interacting with their government, which should be here to protect them, not to separate them from their families and really aid in a broken federal immigration system. So thank you, Senator. I think that's exactly right.
Okay, Senator Lee, all squared away? Okay, great. So next we have Senator Casserly, Senator West, and then Senator Hettleman. Got it? There you go.
There I am. The picture keeps moving around here. So I go to click the button. You keeps jumping away from me. I'm not that fast. I guess my first really, Mr. Chairman, with the question to you, because I did note, following along, I guess it was Sheriff Gaylor that talked that on the 287G program aspect of this, that the 287G program is in the hands of the Biden administration, and it's nothing more and nothing less than a request by that administration in whatever form they decide to go forward with it to look to state and local law enforcement and say, give us a hand with this. And it just seems to me that this bill would say, no, Biden administration, we're not going to work with you on this program. Don't we feel this is a little bit premature here? Because as Sheriff Gaylor said, you already are seeing changes that he's already seeing in the program. So don't we want to withhold and let the Biden administration move forward and at least try to give them help in removing violent predators from our communities?
So I would say that there are two-part answer. One is that, as mentioned in the opening, I worked for Homeland Security when President Obama was in office and when President Biden was vice president. And, I think that's a tough conversation to have amongst folks that, are really proud to participate in that administration and proud of our president. But that, the administration's record on the implementation of immigration policy is something that we're going to have to wrestle with, and is something that, from my perspective, wasn't one of the brighter shining lights. Now, as I say all that to say that, look, I have hope in the next administration, but there's no guarantee, and what we can guarantee is what we do here in Maryland, as Sheriff Geller spoke to. It talks about the correctional facility. Now, I want to, this is some of my line of questioning when we go into it, because I want to kind of parse that out a little bit. When someone's in a correctional facility, I guess the question then goes, well, why do you need to report someone's, immigration status? Why do you need to report that information if you've already kind of got your hands around the person for any sort of criminal conduct? And it doesn't, again, there's several instances in the bill. It kind of reiterates that it doesn't preclude cooperation in the criminal realm. The criminal and the civil are separate. And so I guess I would just say that it's not necessary to increase the kind of the security proposition for our communities when you separate the criminal and the civil. And so, look, that's a complicated thing, especially for me, a Democrat and a proud, Obama person. But I'm hopeful for the future. But we have a responsibility here in the state of Maryland. And when you look across the country, the jurisdictions have gone forward with this. I talked about New Jersey. I think you've seen some pretty fantastic results. I mean, I'm really encouraged by their work.
Yeah, I would just hope that we could be more of an open partner with the administration as they wrestle with these very difficult issues, rather than shutting it down right up front. And I think that's the unfortunate part about this. I mean, the real challenge I have with the bill is that it doesn't distinguish between the lady who, some of these, we hear these anecdotal statements that she was picked up while she's picking up the groceries, or the guy who's cutting a tree, versus the hardcore MS-13 rapist, murderous, cut your head off kind of person. And that's the challenge, is we're just going to bring all that together under one umbrella and say, well, but they're just people who are undocumented, and so we treat them all the same. And that's the challenge of this bill. It doesn't give the Biden administration any flexibility to say, well, wait a second, we need some help over here because we don't have a real national police. We rely on the state and county law enforcement by and large to help out our feds. But I'm just going to give you a scenario, if I can, that it's sort of hypothetical, but it's not too hypothetical, and because it kind of expresses my concerns with this, and ask how you think this bill impacts that. And it's, so, I mean, if you have a detainee who's currently a detainee who enters the U.S. illegally on Monday, and then the feds learn of this, and they place a federal immigration detainer. Just a detainer. They can't do a warrant. Just a detainer, because based upon CIA intelligence and the like, that they know that this person who just crossed over the border is an associate with MS-13 gang members, and who's actually suspected of being a hitman, MS-13 hitman throughout Mexico, and is evaded prosecution by their authorities in Central America. But of course, you can't obtain a judicial warrant based upon that some FBI guy, a source that somebody was saying something on a wiretap or something somewhere in El Salvador somehow got picked up. It's kind of tough to get yourself that. But so there's no probable cause there's not sufficient information to obtain a probable cause warrant under the U.S. Constitution. But then on Tuesday, a day later, this person spotted by Montgomery County Police, who were investigating a brutal MS-13 murder in downtown Silver Spring. That's a brutal rape, murder, cut their head off, kind of typical MS-13 stuff. And they notice a bulge in their jacket, in a normal stop and frisk. They realize that's a handgun. The person has no IDs. There's no registration for the handgun. So they process them for charging on the handgun. They go before a district court magistrate who says, well, I got a guy who gives me, he's a Hispanic guy who gives me a local address. He's nicely dressed, and you've got no police record on him. He's in here for a handgun charge, so I'm gonna release him on bail. He is able to post the bail, or even in Maryland probably no bail, and so he walks out, and then of course 2 hours after he's released, he goes ahead, since he really is an MS-13 hitman, kills somebody else in Montgomery County, and then flees to Central America. And then a week later, a new MS-13 hitman from Central America enters the United States through southern Texas, and the process begins all over again. So this is sort of the nightmare situation that a lot of us are worried about, is we really prioritize protecting Marylanders, 13-year-old Maryland girls who, of whatever race, religion, national origin, get brutally raped because they dated the wrong guy from the wrong MS-13 gang, or they diss somebody, or some guy who pisses off the MS-13 gang. And so how do I what can you tell me about this bill that doesn't alleviate my concerns, that by the provision in this bill that says, hey, we can only cooperate with you if you've got a federal warrant, which we have heard in repeat, every year this thing comes up, we hear from the federal authorities that getting warrants is very difficult, usually as detainers, because we're operating based upon intel and not based upon sworn affidavits and the like. So you're not going to get that. And of course, if you go to that standard, then the scenario I just gave you happens. What's our response to that? Because people are concerned.
So I would say that there are two examples that you've outlined there. For the first one, someone comes over, they're suspected of terrorist involvement or activities. So I think obviously, first baseline, once you're in the United States, the Constitution applies to everyone, no matter who you are. Second is, if they've observed that person crossing over, while unlawful presence is a civil offense, the actual act of crossing over is criminal. And so I guess you could nab that person there. And I guess I would struggle to understand why, an actual wiretap or any sort of intel would not be probable cause to nab someone, regardless of their immigration status. So I guess I don't get that. But then for the second example, if someone, let's say they get, in Montgomery County, for instance, they get arrested they have a gun charge, and then they're released on their own recognizance, which probably wouldn't happen in Montgomery County necessarily. I can't speak for the judiciary, but the judge has made that decision, has balanced the public safety interests with, the interest of keeping that person incarcerated.
In Montgomery County, if my only charge is I have a unlawful possession of a handgun, no prior criminal record whatsoever, I give a local address, they're not going to release me pending trial? They're going to hold me for 6 months until I have my trial?
Yeah, I couldn't speak to what the judge would do, but that's the judge's discretion.
I can pretty much, my understanding is you're walking out of that door because because when you spoke earlier, you're saying, well, the person is now in detention, so they can't do any harm anyway. But under the way we're doing bail now is, no, the odds are they're not in detention. That unless I've got you on some really bad stuff, you're walking out the door. And in my scenario, they don't have that bad stuff. And I would submit to you that intel would not be, where intel is, well, we kind of hear this guy's name come up. It's not grounds for probable cause for an arrest under the U.S. constitutional standards. You couldn't arrest me or you based upon this kind of evidence, but it's the kind of stuff that intel relies upon, sort of third person kind of stuff. So I can't accept that.
If someone's on a wiretap, I don't know. I think if someone's on a wiretap, you're definitely going to surveil that person. You may have some more information, but
but you didn't get it yet. Well,
look,
leads to the deeper.
I don't want to go down the bail thing because it.
Yeah, no, I got it. That one's it is what it is. But the deeper problem here is if Montgomery County Police pick me up, they can interview probably 10,000 witnesses from the day I was born up until today. They'll know everything about me. There's no part of my life that they can't find a witness. Just a short drive down the road, they can interview people, everything about me, they'll know everything. They have all my financial records, etc. But if you're an MS-13 gang member and you came across the board, I don't know anything about you. I know you were here today. And so it just seems like what we're saying is there's two standards here, that if you're in the country illegally, then the police are going to have their hands tied. They can't find anything about you. We're just going to shut them up and you get a free go card versus those of you who've been living here all your life, whether you're a documented alien or not. Even if I was here undocumented, you'd still know everything about me. You can, my friends, my relatives, my family would all be here. But for these folks that we're talking about, I know we know zero about them. Police investigations are virtually impossible for these people. And it just seems like we're developing two different standards here, that if you just walked in the country, cops have to operate blind. Other group, then no, you can ask anything about me you want.
Nothing in this bill precludes there's suspected criminal activity from any sort of investigation or inquiry or records check for that person. if they're involved in criminal activities.
But it does as a practical sense because I don't even know where they're from. I can't even ask you where the person's from. I'm going to start calling around the entire world saying, "You ever heard of this guy?" I'm just at a loss to how we even begin the check if I can't say, "Where are you from?"
Well, that's the constitution. I think those are the constitutional issues that I think even you voted for that provision of the bill a couple of years ago.
Yeah.
It was separate.
Here, my next question is it says on the page 2 of the bill, it says that a registry for the purpose of discriminating. So I can't see anybody doing something just for the purpose of discriminating. You're doing it for the purpose of law enforcement. So is this saying even though the effect is just it may be discriminatory, it's really not the purpose, it's the effect that you're going after.
Well, this part speaks to the maintenance and creation of a registry. I think the part that you may be talking about is farther down in the bill.
What's the same language is continued on the next. They talk about so this would only be for. Is somebody doing such a registry? I'm not even aware. I don't know where we had that problem.
Not that I'm aware of.
Hypothetical problem there.
No, I'm unaware of a registry that's created.
Yeah, I'm not aware of anything either. I was just assuming that would be some kind of a list that law enforcement might create within their community, which maybe did say, well, here's the guys from Honduras that we suspect might be, and because they broke them out by Honduras or El Salvador or Nicaragua or whatever, that because it was broken out, that maybe that would be an unlawful thing to do as they're trying to figure out who's MS-13 and who's not.
No, I'm not. This provision wouldn't cover that if it's if you're trying to maintain an intelligence file for criminal activity. It's kind of different.
Okay. On page 4, it talks about on line 8, law enforcement agent may not during the performance of regular police functions, and I'm assuming from what I'm not really sure. Does that apply then to post arrest? Does that apply to conduct in the detention centers like under the 287G programs?
Can you say that one more time? Sorry.
Yeah, look on page 4. On page 4, lines 9 and 10, it says the police cannot inquire about an individual's citizenship, immigration status, or place of birth. During a stop, got it. Search, got it. Arrest, got it. But does that apply to the post-arrest processing and detention?
So that's the intention for. So it's not drafted that way, and I don't think that's the intention. So this is all pre, I guess, incarceration.
So this would not have impacted the 287G program, because everything we've heard from the two sheriffs is that doesn't begin until you're in the detention center and you've been arrested and they're processing you, then they make the inquiry. So this provision here would not inhibit in any way 287G.
Well, look, I'll say this, it would, in the sense that, and if you look farther back on page 7, lines 20 through 22. I mean, it precludes the state, any entity in the state, intergovernmental service agency, or any other agreement with the federal government for any purpose related to civil immigration. So that's the end of the program there.
Okay, so that right there, that ends 287G, right?
That's right.
Okay, so our intent is to cut that program out. All right. And then back on page 4, line 22, it says without a judicial, 19th thing, it says without a judicial warrant, a law enforcement agent may not, pursuant to a request by federal immigration authorities made in relation to civil immigration enforcement, transfer an individual to federal immigration authorities for the purpose of civil immigration enforcement. I take it by line 22, you mean that includes a person already in custody for another crime.
Well, it's with the exclusive purpose of just for the immigration enforcement or immigration status. So if there's a underlying criminal piece that's relevant to the federal authorities, then that doesn't preclude that transfer or cooperation.
And then looking on page 6, it says that at line 11. And it's just the reading into that, it says, except as provided, blah, 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 that no employee of the state or local government may not, and then line 3 says, contact federal immigration authorities regarding an individual who may be subject to civil immigration enforcement. So they can't even say, hey, I understand that you're looking for this guy because you think he's an MS-13 member. We're not going to hold him, but so they can't even call and alert the local INS or anybody, even without holding him.
Now, I think this provision here, and if you're up here on page 6,
Page 6, 11, 12, right?
11, 12, contact federal immigration authorities regarding an individual who may be subject to civil language enforcement.
So if I'm here unlawfully, I'm not documented. You got something. The Sheriff Gaylor thinks that he's looking at me and he's thinking I'm a really bad guy. He doesn't have anything. He doesn't have a sufficient ground to hold me or arrest me. But he sure suspects that I'm involved in multiple murders and rapes and pillage. He could not call any federal immigration authority to ask questions about me, to say things like, hey, is this guy, you got any detainers on this guy? Has he got any warrants? Has he, do you know anything about him? Can you cooperate and tell me whether you have information on him? Because I think he's a murderer and rapist. He couldn't even contact them.
So not strictly on the basis of their immigration status, but I'm not, I guess,
No, this says that you can't contact them. This says except that they may not contact the federal immigration authority regarding an individual who may be subject. It's not regarding your immigration. It just says if you have somebody who may be subject to immigration enforcement, you can't even talk to the feds. So if you're going after Bob, you can talk to anybody you want and harass me around. But if you're not here, if you're undocumented, then if he's even suspects you're undocumented, if he believes you might be undocumented, he just has to hide the ball.
No, so I see the point there where the language is probably a little bit overly broad. That's certainly not the intent. The intent is to definitely bifurcate the civil and criminal. And so if there's criminal activity or, cooperation that's needed for there.
Okay. And then just to be clear, on page 7, line 20 through 22, that is intended to end the 287G program. And then on page 8, I'm looking at the ID provisions here, line 9, it's section 9102, page 8, lines 5 through 19. And it says that if somebody provides a valid, it says an ID, quote, if valid, I have to accept a driver's license issued by any foreign government. I don't even know all the foreign governments because there's so many hundreds of them. A passport issued by any one of the hundreds of foreign governments, or a document issued by the embassy or consulate of any one of hundreds of foreign governments. I mean, my question is, when people work in a bar or a restaurant, they have to have special training just to be able to validate a Maryland driver's license. We put them through training to say, oh, you missed 25-year-old waitress. We want you, because you've only held your own personal license and handled it and know about it since you were 18 or maybe even 16. So you've had your own, but we're going to put you through it because we don't want you serving Coors Light to anybody who shouldn't get it, a glass of Coors Light. You're going to have to go through special training to be able to recognize a valid Maryland driver's license. How are people, because we feel the need to do that, how are people going to, I mean, I wouldn't know if I saw a valid foreign driver's license or valid any one of these documents, even as an attorney, I wouldn't have any idea. How are they supposed to validate that for purposes of banking, financial, lending them $10,000, financial transactions, for just any kind of transaction throughout the daily lives? How can they possibly validate that, or even have any confidence? So you just have to say, well, this is my Panamanian driver's license, and here's what it says I am, and you got to accept it under state law, and so there's no valid reason you have to give me this $10,000 loan. I'm not getting this.
No, so I flagged that for tightening up. I mean, look, a driver, certainly a passport and documents that are issued by an embassy or a consulate have a higher degree of credibility and acceptance, even now during the course of the normal business.
And certainly they might, but I still see these documents, and I'm like, I have no idea whether these things are legitimate or not. Some of them are flowery, and some of them are, but I have no idea whether this particular country's is legitimate or not.
No, I had that flag for that as well. I mean, especially because my example that I gave was,
the Maryland driver's license has all kind of indicia to prevent tampering. That I'm sure you didn't lift the photograph off and put a new photograph on, although some 17-year-olds do a pretty good job of trying. It is pretty difficult, to do that. We've got all those little reflective things, and we keep, every time I get a new driver's license, they've embraced new technology to avoid fraud. So that concerns me. Page, at the bottom of that page.
We move on real quick. I mean, look, like
Yeah.
I applied that as well, but the
Okay.
policy position and the purpose for that, I mean, is to ensure that these documents, when valid, right, they're able to present these to law enforcement or any other government official and say, look, like, this is valid. I am who I am. And that it should be used for that purpose. So look, I got it. Passports, documents issued by an embassy or consulate, I agree. I had that same conversation and I definitely flagged that, but I think the policy purpose for it still stands and is valid.
Okay, and then the same page, lines 21 through 26, it says a unit of the state government or local government shall notify any individual who is subject of a request or inquiry made by the federal immigration authorities relating to civil immigration enforcement that the unit has received a request or inquiry, and you have to do that in 48 hours. This just seems like it's a give a rabbit a chance to run. I see no valid purpose for this other than to say, hey, we just heard, we know the feds are outside looking for you, and so go out this door, or I can't tell anybody anything. Why in God's name would we want to pit Maryland law enforcement directly and obviously and grotesquely against federal law enforcement in some sort of hide the rabbit game? I'm just totally mystified by this.
No, so that's certainly a subject for discussion and certainly amongst the provisions of the bill, not the most important.
Right. And then getting into here, I'm sorry to be long, but page 9, I don't know what we're getting at here. I read this through. It's this section. It's a financial state finance and procurement section 7-240. Just generally, what's this piece do? I'm not understanding what this one's about.
What's 7-240 from lines 18 to 31 down there?
Yes, and then the next page too. Just briefly, I just didn't understand what we're trying to do here.
So this is just saying, look, you can't spend money or receive money to maintain that type of the register we talked about earlier. It's kind of a follow-on, tack on to that previous clause.
Okay, so it's tightening up on what you can spend the money on. All right.
Yeah.
If I can just indulge for just one final couple, real quick with Sheriff Gaylor a quick question with him, and that would be, Sheriff, we had some testimony on the 287G program, not yours, but other folks addressing it, and I'm just trying to understand. I think yours has been in place for like 5 years or something in there, and I'm just the folks that you're picking up, the majority of them, where are they coming from? What are they arrested for? Can you give a little bit of stats on that?
I don't have that right in front of me. I do have our 2019 stats,
Okay.
Which over 4,500 people were screened, meaning that they came into the jail being arrested by one of the law enforcement agencies in our county and being brought to the commissioner's office and for initial appearance to the jail for initial appearance to the commissioner, or that they were sentenced. So, a judge has sentenced them and they're reporting to serve their sentence. So that's the two ways they can enter the facility. Slightly more than 4,500. 191 of those 4,500 were foreign born from 49 different countries. So it's not just one country that is, we're having an issue or that Immigration and Customs Enforcement sees entering here, but 49 different countries. And the number one country was actually Germany. Number two was El Salvador. And I don't have the entire list in front of me. But out of that 4,500 people who were screened, 43 Immigration and Customs Enforcement filed 43 detainers. And of course, once someone has a detainer filed on them, they still have a procedure within the federal system to fight deportation. So, it's not. I think it's sold as a mass. It's viewed by many as being a mass round them up immigration and deport policy or thing, and it's just not that.
On the 43 that detainers were issued on, do you have any info on what the charge was that they were brought into your detention center on?
I do not have it in front of me. We could break that down. I could get it to you and the chairman and the members of the committee.
I'd just be curious what that's looking like. I mean, because I would suspect that since you had 191 of them and 150 of those, or over 150 of them, were screened off at the top, that's probably your tail light out and stuff. And then as you're getting down to the 43, perhaps it's worse. But maybe I'm wrong. Maybe that's not a valid assumption. So I would be curious to know what kind of offenses we're looking at for that. So,
Right.
I will get that to you, Senator Castley, Senator Smith, and members. Just to that point, the 287G program identifies those who are here either illegally or foreign born, and some of that number is going to be people who are in the country legally, just foreign born. Of the 191 are foreign born, but it's from that point forward, it's all based on ICE's priorities. So again, they have changed under different presidential administrations, but even this current new presidential administration is reviewing their priorities, but they still make it threats to national security, public safety, and border security. So someone could be brought in on something, and I hate to use the word as minor as a DUI, because a lot of people's lives are lost to drunk drivers every year. But somebody could be brought in on DUI, and the federal government, Immigration and Customs Enforcement, could have more information on how that person is a threat to national security or public safety, and mark them for removal proceedings. But I will get you those for those 43 individuals.
thank you, Mr. Chairman, for indulging me. Thanks, Sheriff Gaylor, for your testimony as well.
Yes, sir.
I think Sheriff too. I mean, you're not an employee of DHS, but I mean, I think that one of the levels of consternation is that the kind of the scrutiny that's applied for a detainer to be issued in the first place, and that maybe that's not up to snuff, right? So because you could literally be GS11 issuing a detainer, and then that goes forward, and that I think that's a level of consternation and kind of concern for a lot of folks, because there's just a lack of scrutiny on the issuance of detainers in many circumstances.
Yeah, and again, I'm not. Yes, as far as the detainers are issued by civilian members of Immigration and Customs Enforcement, that the whole thing with judicial warrants, which are just really never happen. But again, how that inner working behind the scenes is something I'm not firsthand familiar with. I don't know if Sheriff Jenkins could add better. But again, they identify on their priorities and decide to pursue removal proceedings. And as the Sheriff of Harford County, my interest is the safety of our citizens. And if they say someone's a threat to public safety, national security, then there's somebody I don't want to open the door to and let them back into our community.
Awesome. Thank you for that. All right. So now we have Senator West and then Senator Hettleman. Senator West, you're next.
Thank you, Mr. Chairman. Am I okay?
Yes.
Saying that I'm not allowed to unmute myself.
You're on mute. You're good to go.
Okay, thank you. I just have two areas that I want to inquire about. So about 18 months ago, my wife and I were directed to show up at an MVA office with lots of paperwork in order to get our new driver's licenses, which had stars on them. So we had to bring our birth certificates and all sorts of other documentation in order to get this new driver's license. I'm looking at the restrictions in here. Suppose that, number one, can illegal immigrants receive driver's license in Maryland? And number two, if they can, is this bill going to prevent the authorities from ascertaining the information they need in order to issue the driver's licenses with stars on them to these people?
Remember, so first, yes and no. So last year, and I'll let Mr. Katz answer this if you'd like to chime in, but remember last year we had a bill, Senator Lamb's bill, we got into the weeds on issuance of driver's licenses for non-citizens. And Mr. Katz, I'm hazy on it, but you can try to shed some more light on the actual documentation that's required, but it's not obviously, it's not to the same level of scrutiny, but it also is afforded a different, it's a class, I forget the class of it, it's class B or something license, but the documents that are required for submission are not the same, right? So Mr. Katz, go ahead. And I think that's been on the books since the O'Malley administration.
Yeah, thank you, Mr. Chair. I mean, that was something that CASA was deeply involved with, and I think you're correct. It dates back to Governor O'Malley, and essentially the difference is, I believe it's called a Class U license, and it's available to individuals who can't meet the requirements of the Federal Real ID Act, right, which is how you get the star on your license. But we decided as a state correctly that it was in the interest to have individuals who may be undocumented but live and work in here, able to operate motor vehicles and go through the licensing process to keep our streets safe, to keep people safe, and to enable people to live their daily lives. So, I mean, this bill certainly wouldn't do anything to change that or stop the MVA from issuing those types of licenses that are slightly different from the Real ID license that you're referring to, I think, Senator.
So you're saying that there are different classes of licenses, and
correct.
The license I have with a star on it would not be available to illegal immigrants. They would get their own different license.
It's a different class of license, but yes, Senator, it's slightly different. So it
could now with this different class, I understand that the new rule is I'm not allowed to get on an airplane these days unless I have a license with a star on it.
Mm-hmm.
Can the illegal immigrants fly?
I mean, I think immigrant members, that's a complicated question that has to do with federal law, which is the Real ID Act and others. I'm not familiar with the full scope of implementation. My understanding was, it depends on the state in terms of when you're actually going to be required to have that, what's called the starred license, the Real ID compliant license to fly. But that's not something that's governed. That's not something that Maryland has control over, right? I mean, that's federal law. That's the TSA that deals with those. I mean, in our state, what we've done is just decide that it's in our interest to provide licenses and have immigrants go through the process of getting licensed and meeting their requirements to receive those.
Right. So as I understand it, illegal immigrants are qualified to get a lesser driver's license than the one I have, and that this bill would not preclude the state from asking the illegal immigrants the information that the state needs in order to confer on them those lesser licenses, right?
That's correct.
It's a different class of license, and yes, that's correct.
So,
okay.
Senator, this is my understanding also, like for Real ID compliant licenses, you need that for like entry into federal buildings, maybe flying on airplanes, things like that. But
going to Canada,
that doesn't mean that a non-citizen with a valid passport, for instance, TSA will still respect that, and that doesn't have any bearing on your citizenship status. So, like if you had dual citizenship or something like that, or you were a citizen of one nation but not the other, you could still fly with that and not a Real ID compliant. You know what I'm saying? TSA accepts foreign passports.
My guess is most of the people who illegally come across the southern border don't carry passports with them, but I may be wrong.
I'm just being responsive to your hypothetical.
Okay. So let me go to my real concern with this, and I'm going to just lay it out. I'm quite comfortable with allowing people who have illegally come into this country and are living in this country legally and trying to achieve the American dream the way most of the rest of us have our entire lives, to have them not be harassed and not be discriminated against. On the other hand, if somebody comes to this country illegally and then violates our laws, especially commits violent acts in violation of our laws, I have no sympathy for them. It seems to me we should deport them and send them back where they came from. So with that as a predicate, is there anything in this bill that would prevent or harass the lawful authorities in this state from facilitating the deportation of illegal immigrants who've come to the attention of the Maryland law enforcement authorities who have committed violent acts in violation of our laws?
So first I'd say, and I think everyone on the call agrees with your statement, right? That we don't want, if you are a violent offender, then you should be, you should be subject to the criminal laws of your nation, and let the the laws wash over you as they see as is fit. But nothing in this bill, and it's certainly not the intent, but nothing in this proposal would prevent our government, federal or state or local, from cooperating to fully implement criminal law and to ensure that those people that break the law are held to account. And if, under your hypothetical, that leads to removal proceedings under those circumstances, nothing in this bill would prevent that.
Well, let me then ask about language on page 4. Starting at line 8, it says a law enforcement agent may not, during the performance of regular police functions, and going into line 17, transfer an individual to federal immigration authorities unless required by federal law. Now, assuming that federal law does not require states to transfer violent offenders who have been convicted of violating the state's laws to federal authorities, if that's not, and I doubt that's the case, wouldn't lines 8 through 18 preclude Maryland law enforcement authorities from transferring a violent offender to the federal immigration authorities?
So my reading is that it's based purely on the civil detainer or the civil immigration inquiry. If that was the kind of the basis of the interaction and the underlying arrest and or subsequent inquiry with, or attempted inquiry with federal government. So I don't read it that way, but
I'm just reading the language and read the language sequentially without eliminating the stuff in between that's not applicable. A law enforcement agent may not, during the performance of regular police functions, transfer an individual to federal immigration authorities unless required by federal law.
which line are you on specifically? Because I'm reading.
Well, I'm on lines 8 and 9, and then I go down to subpart 3 at 17 and 18.
So are you on page 4?
Yes.
Okay, so I'm on, okay, I see that, performance of functions, line 8 and 9, and then, so 10, 11, inquire the individual citizenship, immigration status, place, birth, blah, blah, search.
Yeah, I'm skipping over subparts 1 and 2, going right to subpart 3. So to read them together, a law enforcement agent may not, during the performance of regular police functions,
Got it.
transfer an individual to federal immigration authorities unless required by federal law.
Well, I think that goes to the whole establishment of this probable cause for criminal activity. I think that would be fine. I mean, that if you have the probable cause to arrest someone for suspected criminal activity, then this doesn't preclude that. So
why not? I'm just looking at the language, reading the language and giving it its normal meaning. It says a Maryland law enforcement person may not transfer an individual to federal immigration authorities unless federal law requires it. I'm assuming federal law doesn't require it. So it seems to me a straight prohibition on any transfer of an individual to federal immigration authorities, period, irrespective of why they're being held by the state authorities. They could be held for speeding violation or for first-degree murder. Doesn't seem to differentiate.
So no, I mean, look, that's certainly not the intent. And given the prior 6 or 7 lines, I mean, it's very clear. It could be more clear if you're reading it that way, but it's certainly not the intent. The intent is to, you have to have probable cause for the criminal activity, and the foot stomp there is that it's not based on just the civil immigration status, the immigration status. So, I could certainly tighten up the language there, but that's certainly not the intent.
Okay, thank you very much, Mr. Chair.
All right, Senator Heddleman, there you are. Hold on.
Thank you very much, Mr. Chairman. Nick, if I could go back and ask you a question. There was some discussion about the immigration policies under different presidents, and going back to President Obama with President Biden as vice president, and now as our new president, President Biden. Can you talk a little bit about, and you've been involved in advocating for this bill, I think, throughout those different presidencies. Can you just talk about why you think this is important to enact this legislation, regardless of who is at the helm of our federal government, please?
Yeah, certainly, Senator, and I appreciate the question. I mean, I think Chair Smith pointed this out as well, right? I mean, he was a part of the Obama administration, and when you looked at it, I mean, there were serious issues with sort of how enforcement was engaged in at that time, and obviously those got much worse under the Trump administration. So I think a lot of individuals are looking to the Biden administration to radically reform our immigration system, and we certainly support that. And there's been some positive action at the start of this administration, frankly, because of conversations like this, right? And because advocates have been pushing, and candidate Biden and other, individuals at the federal level to change the way we think about immigration and immigration enforcement. But regardless of what administration is in charge, you still have this infrastructure of civil immigration enforcement that's rooted in law that needs to be changed by Congress, that criminalizes our communities and puts our individuals at risk. And the bottom line of this legislation is really just, we're going to separate Maryland out from that, right? That's the federal government's responsibility. They should be doing that. And hopefully they'll do it, you know, in a more humane way under the Biden administration. But it's not going to change these examples that we've heard on a fundamental level. It might make it, you know, a little bit, maybe a few less people will be affected, but it's still going to be an issue. And I guess the other point I would make is even as, you know, now President Biden, you know, tries to change the system, there's a strong anti-immigrant sentiment from around the country that's fighting against those efforts. And we've seen that already, you know, evidenced by the moratorium on deportations that President Biden has attempted to enact, that has within a matter of days been shut down by anti-immigrant, you know, advocates in Texas. And so it's, I think, incumbent upon us as a state to affirmatively protect our immigrant communities and not rely on the federal government to do that job for us, right? Because I think history has dictated that that's not something that's going to happen. So that's why even under a Biden administration, I think this bill is just vitally important. And finally, you know, there's been a lot of discussion, you know, about the criminal justice system and immigration and sort of trying to facilitate the transfer of individuals who've committed serious crimes into that system. I mean, I think I would just go back to the points I made in my testimony, which is, as Chair Smith has mentioned several times, right? There are mechanisms within the criminal justice system for those to be resolved, and the courts, our courts will decide it, our judges will decide it. It's not helpful for us to facilitate the transfer of those folks to civil immigration enforcement. If they have probable cause and they can get a warrant, there's nothing in this bill that prohibits that from happening. But the civil aspect of it is what's being dissociated, and that's where the transfers are prohibited. That's where the facilitation of detainers and notification requests is being prohibited. So I think that's a crucial point to emphasize. But thank you for your question, Senator.
Thank you.
Actually, it's funny that during the dialogue, I should have mentioned this earlier with Senator West, but I had a chance to read on to the second page. You can find a follow up on his question. I know he's not here now, but I think, so when he's talking about that question, to transfer the individual to a federal immigration authorities unless required by federal law, I mean, I think if you go to the next page, I'm not sure this would, you know, assuage his concerns, but under subsection F, you know, nothing in section will prevent a law enforcement agent or state or local correctional agent or employee from responding to a request from federal immigration authorities for information about a specific person's criminal record requested by state or federal, or a lawful subpoena. So I you know, I think that gets to what he's talking about, that there's nothing that prevents that. And I guess, Nick, you just tied that up nicely at the end of your comments, but all right. Looking around the Zoom room for additional questions. All right, we're over an hour and a half into this one, so we're gonna, okay, we've got Senator Bailey, here you go.
Thank you very much. Just a couple questions. I would say, Mr. Chairman, that I definitely do disagree with that point that was just made. And not saying that this is the most politically correct statement, but where I come from, we would say there's things that happen where we throw the baby out with the bathwater, and that could very potentially be happening. And I want to just ask a couple questions when we talk about rules of arrest and we talk to the sheriff and Sheriff Gaylor. Real quick question: your deputies catch an individual or a person he's committing a criminal misdemeanor in plain view of your officers, and he has no identity, right? And he cannot prove satisfactory form of identity. What happens to that individual?
He'd be arrested and taken to the detention center where he'd be fingerprinted and photographed. And we tried to identify him through the fingerprints.
Okay, that is exactly what would happen. And then at that point in time, that's when you would at some point potentially reach out to our federal partners to identify who that person possibly is.
Yeah, yes. Again, with the 287G program, corrections based, when they are booked into the detention center, the additional step of the 287G screening takes place. And if they are found to be in the country, foreign born is what you first identify, and then you have to determine whether they're in the country legally or not. And then that's reported to ICE, and then ICE decides, again, based on their priorities, if they are going to take additional actions.
Okay, thank you very much. So, Mr. Chairman, my first question deals for you. You used an example of the fact of a person was cutting down a tree, right? And then he ended up dealing with immigration. Well, as I think we're all familiar, Natural Resource Article 5 is criminal misdemeanors, right? Any person cutting a tree illegally in Maryland has committed a misdemeanor in the presence of the officers. Those officers simply did what they are required to do. If that person has no identity, you have to treat it just like any other criminal misdemeanor. And so I didn't really understand that example, because that example just doesn't hold water the way that I think we say, well, because it was a natural resource crime, it's not important. I think it is important. And I think if somebody doesn't have an identity, right, then they have to be dealt with accordingly. The fact is, if a person, and the sheriff can back me up on this, if a person, when we write a citation, when a police officer writes a citation, the person signs that citation saying that they will either pay the fine or come to court. If that person has no identity and we can't tell who they are, what happens to that person, Sheriff?
Well, with the e-tics nowadays,
So a criminal citation, not a traffic citation.
Gotcha. Yeah, it would be just as I described before. It would be taken to the detention center, booked in a 287G county. They would be screened to see if they are also in the country illegally.
Okay, and then we would work along with our, so I do have some questions, and obviously, Mr. Chairman, we can discuss it more in depth, but I do think that there's a potential when we're talking about law enforcement likes rules, we like to follow them, right? And we need to know the process. And we are severely muddying the water here with a process that the way law enforcement has been operating is pretty clear. There are numerous examples that we can show of people that have been deported numerous times. They've come back. They have created right here in our state heinous crimes and killed individuals here that should not be here. And we do not want to take a tool in the toolbox away from law enforcement when we're dealing with that. And that's one of the things that I think that I struggle when we deal with this. But thank you.
No, I appreciate the perspective. I knew you were going to hone in on that DNR vignette there. So I knew I was going to come back. But I guess those just used to kind of, I think, just talk about I think it provides a little kind of a face to the problem, but then also it shows the difference between state policy and Montgomery County policy. But for I was wondering when you're running, for your example about the ID piece, why do you, if you can run that check, like you run a NICS check, right? Why do you, so I know that's, I guess that's, you're running through a database, but then why does it require like an additional inquiry or like side inquiry to a federal agency to confirm identity? Or is it just, I'm just trying to figure that out. If you're trying to confirm the identity of someone, if you're running a NICS check, why do you need to do like another contact? Maybe I'm not understanding the process right, because I think, my understanding is that you run a check that's kind of like, you could do that alone. You don't need to have like, you just do that. That happens at the department.
So they come back with no identity. You don't know who they are.
So then you contact, let's say, whatever, you contact ICE or you contact DHS or you contact DHS and you try to discern their identity because maybe they have information that's not within the NICS system. Is that, I'm just trying to understand the process.
So there's two processes here. I'm gonna deal with the first one out there on the street, and then I'm gonna let Sheriff Gaylor answer the second process. First process is when you're out there on the street and you're dealing with somebody that's committed a non-traffic misdemeanor violation, and you can't prove who they are, right? They don't have any identity. They don't have a driver's license. They don't have some form of identity. And if they've got trailer registration, something that comes back to them, right? Officers have a lot of leeway here, but you cannot write a bad citation, right? That is an officer's due diligence They have to know who that person is. It's right in the criminal code, says they have to be able to prove who it is. So they incarcerate the individual. Then they bring him into the detention center. Now, Sheriff, I'm going to turn it over to you.
Right. And again, as part of our, I think on the first part of that, a lot of things are done on the road where people don't have their license with them or don't have something, maybe don't have a license, and they can be run and their identity can be confirmed on the roadside. So this is in those instances where there's, it could be a DUI on the traffic side, or it could be some other arrestable offense where you can't identify, no matter what you do, you can't identify them to positively identify them. So you place them under arrest, take them to, again, Harford County Detention Center, where they'd be fingerprinted and photographed. And when they're fingerprinted, you're sending that to the federal government. That's going out through the national crime. They call it something else, NCIC of old. So that's more or less a federal check. But with 287G, we go one step further to see with our screening to see if we could identify them.
Got it. Thank you very much for that.
Yes, sir.
And I think, did Senator Sidnor have his hand up? There you are.
Yeah, sorry. Yes, I did, but I think your follow-up was kind of in line with what I was wondering, which was whether or not we all needed to go around with identification. But I was wondering about the next step in the process as well. So I think it's been answered. So thank you.
Got it. And then Senator Jackson.
Yeah, thank you, Mr. Chairman, and thank you for the proponents and opponents. Good to say hello to my sheriff folks, and congratulations, Chief, on your interim appointment. Just to kind of follow up on, I certainly want to speak to you much more about this piece of legislation going forward, but I just think for everybody on the call, there's an identification process that's due with any intervention with law enforcement from a public safety and an officer safety standpoint. And if we don't have the information on an individual, then, it's the fingerprinting sends off that information. It goes off to all federal agencies. So in some cases, it's only 3 counties now, but the 287G component, may register something, or the basic fingerprinting and sending it off to the federal government, to the federal agencies may do the same. So I'd like to delve more into the bill as we go forward, and where we can help clarifying some things as we continue the hearing process. So thanks.
No, thank you very much, Senator Jackson. Both you and Senator Bailey have been a value add instantly from your membership on the committee. So we really appreciate your expertise and perspective and background. Okay, so looks like no further questions on the screen here. And with that concludes the testimony and the Q&A for Senate Bill 88. Thank you, everyone. Thank you, everyone, for your time on this matter, and stay safe, and I'll see you all later. So next we will move on to Senator Elfreth. I think I saw she was in the room. Senate Bill 253. Senator Elfreth, you are up.
Thank you so much, Mr. Chair, Mr. Vice Chair, members of the committee. For the record, Senator Sarah Elfreth, representing Maryland's District 30. I'm happy to be here today to present Senate Bill 253, which I think is a small bill that passed unanimously in the House last year, came over, but was kind of a victim of our shortened session. In short, the bill tries to right a wrong that is happening, I know in my county in Anne Arundel, but I know it's also happening in other counties around the state, where unfortunately we have overcrowded buses school buses to the extent that students are standing instead of having a seat. Now, this is a logistical challenge for a lot of our school systems. I understand it's not always easy to fix, but what Senate Bill 253 does, it says that when school systems are routing buses or planning for buses, that they should take into account all of the students who are on that route to make sure from the planning perspective there's a seat for every child. We worked with stakeholders last year, as was Delegate Alice Kane's bill last year, my former seatmate. She worked out with stakeholders to also provide an exception for emergency circumstances, knowing that we unfortunately might have those, to make sure that if it's needed, that buses can go to and from with more students on them than seats available. But I think this is a simple bill that is going to increase safety for our students and not be, prohibitively difficult for our school systems to implement. And I know, Mr. Vice Chair, we have a number of panelists who have experienced this from both a kind of board level, leadership level, but also having students of their own, children of their own experience this difficulty. I ask for a favorable report. Thank you.
All right, thank you, Senator Elfreth. So you have 3 members on your panel. First, we will go with Ms. Booth. Is Ms. Booth here? Where are you? Sorry, we've got a full Zoom room here. I've got to toggle between. Here you are. There you go.
Oh, wonderful. Thank you. Thank you for allowing me to speak today. My name is Laura Booth, and I serve on the Annapolis Education Commission. Transportation is an issue that frequently comes up, specifically overcrowding on buses in Anne Arundel County. We had a parent that came to our commission during the previous school year who said that her child's bus was overcrowded, and she had contacted the Anne Arundel County Public School Transportation Department to say that there were students having to stand in the aisles while the bus was in motion. And the person that she spoke to said, well, it's not against Maryland law for students to stand in the aisles while a bus is in motion. Now, I feel like I'm so grateful to Delegate Kane and to Senator Elfreth for tackling this issue, because there is a real disconnect in transportation safety here. We are very clear about children in cars. They have to be seated in a seat with a seatbelt, possibly on a booster seat or in a rear-facing or a forward-facing car seat. But somehow when kids get onto school buses, we believe that if they are standing in the aisles, they are somehow magically protected in case of an impact, which we know is not the case. So I urge you to pass this and to make it illegal for school districts to operate this way on a regular basis. With regard to the language, the only reservation I have is that I would like to see it made very, very clear that standing is only to be permitted in case of emergency. If you have to evacuate a school or something in that situation. As it is written right now, I can see how it could be used to say, oh, well, on a regular basis, meaning we only do the bus routes, quarterly. So for the rest of this quarter, this bus will be overcrowded. So I urge you to make it really clear that it has to be a legitimate emergency in order for buses to be run overcrowded. And I thank you for setting reasonable bus capacities. One of the issues that causes overcrowding, especially here in Anne Arundel County, is that we've been told that they will, when they calculate how many students ride on a bus, they expect students to sit 3 students to a seat. Which, for larger children or kids that have backpacks and lunch boxes and musical instruments, creates this overcrowding issue that we see on buses. So as a parent and a taxpayer, I just want to say thank you for helping to keep our children safe. Thank you.
Thank you, Ms. Booth. And next we'll move to Ms. Van Buskirk.
Yes, sir. Thank you. Good afternoon, Chair Smith and members of the Judicial Proceedings Committee. Thank you for the opportunity to testify in support of State Bill 253. I am Lisa Van Buskirk, the leader of Start School Later Maryland and Anne Arundel County chapters. School transportation is the tail that wags the dog of safe, healthy, and age-appropriate school hours, so I pay attention to school transportation issues in Maryland. My written testimony includes additional statements. The 2019-2020 school year brought more complaints than usual about overcrowded buses with students standing or sitting in the aisles around Maryland. In reviewing the language of the proposed bill and the version passed by the House last year, it appears that the provision to permit standing in the aisle has been maintained. Standing in the aisle should only be permitted during true emergencies, and the bill should be amended to state the limited conditions for when standing in school aisles is acceptable. School systems must understand that poor planning does not constitute an emergency. To my knowledge, there are 0 safety systems on school buses for children standing or sitting in the aisle. Maryland law permitting such activity violates the recommendations of NHTSA and common sense. Opponents may argue that this bill will cost school systems more money as they need to hire more bus drivers or purchase more buses. This is a false assumption, as I would argue that overcrowding on buses stems from a lack of regular review of school bus routes for accurate ridership. In 18 of Maryland's 24 school systems, a lack of methodical review of bus systems was cited in their most recent Office of Legislative Audit review. For most jurisdictions, this was the second or even third time the OLA made this recommendation. Maryland has been recommending routing software to review bus routes since the 1975 report of the Task Force to Review Public School Pupil Transportation Program. A report on the Anne Arundel County Public Schools transportation last year found that ACPS could actually save millions of dollars through regular oversight and review of its bus routes. Might other school systems similarly benefit from reviewing bus routes as repeatedly recommended by the OLA to ensure compliance with this law? Please amend Senate Bill 253 as I described to ensure safe operations of Maryland school buses. Thank you.
Thank you, Ms. Van Buskirk. We now have Ms. Tobin. Ms. Tobin, there you are. I think you're unmuted.
Thank you. Thank you, Chair Smith and members of the Judicial Proceedings Committee. Thank you for the opportunity to testify on Senate Bill 253. My name is Joanna Bache Tobin. I'm a parent of a member of the class of 2020 at Annapolis High School. I'm also an educator and a recently elected member of the Anne Arundel County Board of Education, representing the Annapolis area. The views I'm expressing are my own and not the Anne Arundel County Board of Education's. I'm here today to urge you to support this bill. It is essential to secure the safety of our children as they ride buses to and from school and school-related activities. Allowing children to stand or crouch on a moving bus is clearly not safe, nor is it appropriate except in an emergency. Having a statute on the books that allows for or could be interpreted as allowing for children to stand while a bus is moving speaks to a disregard not only for their safety, but also for their dignity as human beings. Our children deserve better from us. The need for this bill first came to my attention when I heard a parent testifying before the Annapolis Education Commission say that when she had called the schools to complain about her child's bus was consistently overcrowded and students were forced to stand, the response was that the state law allowed children to stand on moving buses. I was able to bring this to former Delegate Alice Kane's attention, and she first introduced a bill to remediate the situation during last year's abbreviated legislative session. I'm very grateful to Delegate Jones for reintroducing the bill for the 2021 session and to Senator Elfreth for cross-filing it in the Senate. Passing this bill is particularly important to the students in the Annapolis area. We are a largely urban district with a dense population, and we also have significant areas of concentrated poverty. This means that we have a high number of students who depend entirely on bus transportation to get to and from school. It is therefore especially important that we ensure their transportation is safe and well regulated. Let me conclude by saying that if you support this bill, you will be sending a powerful message to our young people that we value them and their safety. As a parent and an educator, one of the most important lessons I have learned is that children and students don't do what you say, they do what you do. In passing this legislation, we are not just saying that we care about our children's safety and that they should too. We are putting our words into action. Thank you.
All right, thank you very much. And with that, that concludes the testimony for Senate Bill 253. Thank you, Senator Elfreth. We will now move on to Senate Bill 297, and I see Senator Benson is here. Senator Benson, the floor is yours.
Thank you so much. Good afternoon. Is it afternoon? It's after 12, isn't it? Is it after 12?
It sure is.
Okay.
It sure is.
Good afternoon, Mr. Chair, Mr. Vice Chair, and esteemed members of the Judiciary Proceeding Committees. Senate Bill 297 seeks to create consistency in speed limits among Maryland expressways and interstate highways. In its present posture, Any individual traveling Interstate 70 from Frederick to Hagerstown, which is my home, is lawfully authorized to travel at the speed of 70 miles per hour. Upon passing through Hagerstown, individual traveling on Interstate 270 is now required to decelerate their vehicles to speeds of 65 miles per hour. Once again, an abrupt change in speed is introduced when individuals traveling onto Interstate 495 must again abruptly decelerate their vehicles to 55 miles an hour. And by the way, I'm not going to ask you, but I'm sure that you would tell me how many of you do 55 miles an hour on 495? Thank you very much.
Always do the speed limit, Senator
You
Benson.
told the truth. Very
Always.
glad you told the truth. Further complicating matters, adequate signage is not placed notifying travelers of the adjustment. Not only does this pose the threat of increased traffic on our interstates, but it places our drivers at risk of receiving innumerable amounts of speeding citations. This bill would require the State Highway Administration to post notice of the maximum speed limit for an expressway at no greater than 5 miles intervals. This would consequently result in consistency in interstate highway speed. In addition, I am introducing an amendment to this current bill, which changes the speed limit on Interstate 270 and 495 to 70 miles an hour. Now, let me point to a fact here. In October 2015, the state increased the speed limit on I-68 to 70 miles an hour, but did not do it for I-95 or I-270. Our approach to Senate Bill 297 is two-pronged in the fact that it will seek to eliminate ongoing problems with interstate congestion, interstate accidents due to abrupt changes in highway speed. And we have done the research that clearly indicates that if the speed limit is increased, there is no evidence that an increase in speed creates more accidents. There is no evidence that points to that fact. As to be expected, opposition to such a proposal is that this might present the argument that an increase in speed will place drivers at a greater risk. We have no evidence that justifies that, ladies and gentlemen. However, I would like to tell you that on Route 50, I have had very personal experiences coming from 495 down to Annapolis. And by the way, on Route 50, you can do 65 miles an hour until you get to the Bay Bridge. Once you cross the Bay Bridge, you have to decelerate to 55 miles an hour, which creates a problem with the kind of congestion we see when individuals are either going home or going to Ocean City. So I would ask that you all give careful consideration to this very important bill. And I would urge the committee for a favorable report on Senate Bill 297. And up to this point, we have had no one to really oppose this bill.
Excellent. Thank you, Senator Benson. So this means I can go faster on 495. I'm kidding. Thank you very much, Senator.
Thank you. It's good to see you all. And thank you very, very much.
Thank you very much. Have a good one, Senator.
Thank you very much.
Always good to see you. All right, now, so that concludes the hearing for Senate Bill 297. We'll now move on to Senate Bill 315. Senator Young, you are up.
Thank you, Mr. Chairman, members of the committee. Good to see you all. Had to apologize. I'm sure I can't show Senator Benson's enthusiasm. So I'll just go straight into what I
No
think.
one can. None of us can.
A very simple bill. This is a bill to require, or it lays down guidelines for plug-in electric drive vehicles and reserve parking spaces for them. Where they exist, there is a problem with what's called icing. People who move in, use the space, and block electric vehicle users from using it. Last year in the United States, 345,000 additional electric vehicles were sold. It's a growing number each year. Some jurisdictions are providing more and more spaces. Baltimore, for example, has well over 500. But we are not trying to number the spaces in this. We're just asking to pass the law with the guidelines for it. And it would just say that those spaces are reserved strictly for electric vehicles, and it authorizes the local government or private owner of parking to ticket and tow, if necessary, spaces that are being used improperly. It allows the Department of Transportation to set up uniform guidelines for how this should be done so that it's not different from jurisdiction to jurisdiction. 14 states have passed a similar bill already. I would suggest in my bill on the third page, G, I have a $50 fine for violating it. I would like to scratch that because some jurisdictions are already charging more than that, and we have a line in it that allows the state to set guidelines. So with that, it's just a simple bill to reserve the use of these spaces for electric vehicles, and I would hope you move favorably on it. There were a few amendments suggested, but actually I think they're actually already covered in it, and also the state has the transportation has the right to set guidelines so they can address those issues at that time.
Excellent. Okay. Well, thank you, Senator. We'll now turn to your panel and then open it for questions afterwards. So Mr. Van Rens, you are up next.
Thank you, Mr. Chairman, Vice Chair, Senator Young, and members of the committee. Thank you for the opportunity to testify in support of the bill today. I apologize if the quality of my audio or video are not great. Seem to be having some broadband problems this morning, but I'll do my best and hope we can follow along. So this bill presents a simple and easily enforceable solution to a problem that is starting to stymie the expansion of electric vehicle charging networks in Maryland and across the country. The U.S. Department of Energy reported in 2019 that burning fossil fuels to power automobiles, trucks, and other motor transport accounted for roughly half of all greenhouse gas emissions in the U.S., and that plug-in electric vehicles generate roughly 40% of the total annual carbon footprint of gasoline or diesel engines. Even taking into account the environmental impact of manufacturing high-density batteries, the lifetime emissions per vehicle of an all-electric plug-in auto is under half of the most efficient gasoline or diesel cars, and plug-in hybrids are nearly as efficient. Auto manufacturers, including Ford, General Motors, Tesla, Volkswagen, and Toyota, have committed to the electrification of their fleets. As the technology improves and becomes less expensive and more widely available, numbers of plug-in electric cars on the road have grown substantially. For the first time in decades, smaller manufacturers have become viable players in the auto industry, offering all-electric vehicles in specialty formats or retrofitting classic chassis to run on electric drivetrains. Both growing popularity and the looming environmental crisis means that electric cars are overtaking the market, and the network to charge and service them needs to expand. But this accelerating change can only happen if electric charging stations are widely available. Unlike filling a gas tank, charging a battery takes time, so charging stations are being installed in parking lots, at shopping centers, near restaurants, and wherever drivers might park for a while and leave their vehicles. Metering technology makes it possible for the owner of the charging station to charge the driver for electricity, providing additional incentive for these installations. It's becoming a regrettably common practice in some communities to, as a political statement, park a non-electric vehicle, sometimes a large diesel truck or SUV, in a parking space reserved for charging electric cars. This practice is referred to as icing from the acronym for internal combustion engine and is intended to block access to charging stations by vehicles that need them for continued operation. Companies that operate charging networks like Electrify America, ChargePoint, EVgo, and Tesla report that this has gone from a minor nuisance to a notable impediment to network operations in many areas. At the same time, areas dependent on tourism that now include EV drivers express a need for a solution to discourage icing at public and private stations in order to remain attractive to tourism dollars. Per the Christian Science Monitor, the states with the largest fleets of electric vehicles and corresponding numbers of charging stations already make icing a violation on par with blocking a handicap accessible space. These states include California, Washington State, and Florida, and Colorado is currently considering similar legislation. As Senator Young pointed out, Colorado would be the 15th state to enact legislation along these lines. This bill provides municipalities and property owners with clear, easily enforceable regulations to protect electric charging stations, maintain access, and reasonable penalties in the event of violation. Just as we protect accessible parking in the interests of the common good, we should act to provide this protection to electric charging stations in the interests of maintaining user access and making expansion of the charging network practicable. I urge you to vote yes on SB 315. Thank you for your time.
Thank you very much, Mr. Van Rens. Next, we'll move on to Mr. Hurwitz. You're up.
Good evening, afternoon, Mr. Chairman, members of the committee. Urging you to have a much simpler definition for what a plug-in electric vehicle is than is in the code. The definition has unintended consequences, which will actually be a deterrent to the anti-icing, which is the whole intent of the bill. And last year in July, the governor signed the memorandum of understanding for medium and heavy duty zero emission vehicles. One of the goals therein was to eliminate weight restrictions that are barriers to deployment. The 8,500 pound limit actually make it unlawful for a truck to park in a electric vehicle parking space in a truck stop or rest area, actually making it the opposite intent of the law. Similar problems deal with the low-speed electric vehicles, which I know Hartford County was working on. It could also be in conflict with SB 144 with multifamily units if an owner went to put in a low charging spot only to find out that their low-speed electric vehicle or a truck, if allowed, would not be permissible. Montgomery County, Baltimore County, Howard, and Annapolis have all generally adopted the flawed state definition. I've been working with members of the county council in Howard County to remove it since the last 4 years when I first discovered it, including with then council member Gerasa, who now in the House. I submitted in my testimony a simpler definition, and in fact, a few years ago, then Delegate Lamb actually put in an amendment in 2018 to simplify it. So contrary to the earlier testimony, it is not easily enforceable for vehicles other than cars. You have to go through all the specifications that were put into the code to deal with defining vehicles that were eligible for tax credits. And a police officer cannot deal with all those specifications. So a simpler definition, which I believe is found in most other states. In fact, I find Maryland's definition the most convoluted and burdensome definition, would be much simpler, because does the vehicle have a license plate and a plug? That way it would exclude other things that are not eligible for the street. Thank you.
All right, thank you very much. And I think with that, that concludes the testimony for Senate Bill 315. Thank you, Senator Young. We'll now move on to Senate Bill 337. Senator Kramer, you're up.
Good afternoon, Mr. Chair, Mr. Vice Chair, members of the Judicial Proceedings Committee. It is a pleasure to be back with you again today. This is my Judicial Proceedings Week. I'll be visiting the committee yet again tomorrow so that you all know you have something to look forward to. And I am here to introduce Senate Bill 337. And let me preface my introduction by saying that we have a problem. And that problem is that too many motorists now are viewing posted speed limits as a recommendation rather than the law. And as a consequence, we are finding that public safety is routinely being put at risk on our roads and on our highways. In addition to the dangers that our public is being exposed to, we also have a phenomenon that has been growing significantly in recent years. And that is that we are finding motorcycles that are built for racetracks, are sold to the public, and are on our roads. As a consequence, we are seeing a significant adverse impact on the quality of life by those dumbass motorcycle riders who are exploiting these motorcycles. And I'm qualifying that by saying exploiting these motorcycles. I am a motorcycle rider and I respect our law, and I am not one of those who exploits our laws and our roadways. And just to give you an idea of what it is that I am referring to, 5 minutes ago, I brought up an advertisement for Honda motorcycles. And here is one of the motorcycles they have for sale to the public. Unapologetic performance. Long been the holy grail for the best sport bike riders. Powerful, precise machines that stand at the very top of motorcycling's hierarchy. On the track, they command your full attention. On the street, they give you a ride like nothing else with a license plate. And that is the problem. They have a license plate, and now we have these people who are on them and want to find out, what is the capacity of this motorcycle? What will it do? And I'd like to take a break, if I may, Mr. Chair. I believe we have a video that is queued up from just this past summer, taken on Maryland's Intercounty Connector. So if I could ask the committee to stand.
Oh my God!
Told you.
Someone's gonna die! Someone's gonna die!
Told you.
Someone's gonna die! Comes more!
I told you, they're racing.
Someone's gonna die, Mike!
Yep.
I'm scared!
Wow.
I'm scared! Holy shit!
Thank you. I appreciate the opportunity just to quickly show the committee that video. That is what is taking place every day, day in and day out on Maryland's highways. If you are a resident who lives anywhere close by to Indian Head Highway, the Intercounty Connector, the Washington Capitol Beltway, the Baltimore Beltway, I-270, I-70, Route 32, and the list goes on and on and on. This is a routine experience, and making living anywhere near these roadways absolutely miserable. So what is the answer? Well, it absolutely begins with enforcement. And enforcement is a critical component to trying to improve the quality of life and protect our residents on our highways. But number one, enforcement's only so good as long as people are concerned with enforcement. Tight budgets have reduced enforcement capacity and capabilities. And also, we have extremely lax laws right now on the books on this issue. So I reached out to law enforcement, both at the state level and the local level, and asked them if they had thoughts or suggestions as to how we might help address this problem and give them an opportunity to be more effective in what it is they are doing. After several weeks of conversations, there seemed to be a universal agreement that one of the best ways we could do that is to follow Virginia's lead on this issue. And the impression I had was that not only has there been significant improvement in Virginia, but in fact, because our laws are so lax, and Virginia has gotten very stringent on this issue, that we're finding these riders are coming into Maryland to find out what it is their motorcycles may or may not do and to find themselves splattered on our guardrails because of the fact that our laws are so lax. So Virginia on this issue has that anyone that is exceeding the posted speed limit by 20 miles an hour or greater is per se reckless driving and a must appear in the courts. And that this has been very effective in addressing this problem. So the bill before you does the following. At a speed of 20 miles per hour or more in excess of the maximum speed limit, a person charged with a violation of subsection A, that's a speed limit of 20 miles an hour or more, must appear in court and may not prepay the fine, and it is reckless driving. So that gives the court the opportunity to take a look at what is happening, and it forces the individual into a courtroom instead of simply paying an insignificant fine and being back out the following day racing on Maryland's highways. The goal here is to modify behavior. If we don't modify behavior, we can have no expectation of change. Now, the issue has been exacerbated by reduced traffic on our roads during the pandemic, but we're also learning that many of these changes are going to be here to stay. The pandemic has changed the way transportation is happening in the state, and it's very likely that's going to continue long term. So I think we have a responsibility and an obligation to take this issue on, to try to ensure that public safety is a priority, and that we're putting our residents first, and that we are protecting them from those who simply see our posted speed limits as a recommendation, not as a law. And I hope the committee will take action during this session and let's make a change. There is that opportunity. So with that, I thank you, Mr. Chair. I certainly welcome any questions the committee might have. If not, I believe there are a number of people who've signed up to speak to the committee today about the impact that this has had on their lives. So thank you.
Thank you, Senator Kramer. And so basically the bill, look, it makes it a must appear, it makes it that if you're going 20 miles over the posted speed limit, it's a automatic reckless, and then it's a must appear. Person convicted of this section is a fine not exceeding $1,000. Got it. All right. Next we will have, thank you, Senator Kramer. We'll have Mr. Singh. You're up next.
Thank you, Chairman Smith. Do you believe I have 5 minutes for my testimony here?
That's correct. You're the primary witness here, so yeah.
Okay. Thank you, Chairman Smith, Mr. Vice Chair, and members of the Judicial Proceedings Committee. I'm Rockville resident John Seng. I represent the Maryland Coalition for Highway Safety, 125 homeowners and homeowner associations across Maryland. I live less than 1 mile from the ICC, which was the scene of the video that the committee's just seen this morning. I can say firsthand that it sounds like jet aircraft taken off from Andrews Air Force Base every single day in the spring, summer, and fall. Good weather, warm weather. We don't need to even come out of our house to know it's a nice day. We can hear the planes taking off on our highways. The coalition strongly supports Senate Bill 337, and our thanks to Senator Ben Cramer for responding to his constituents to create this life-saving bill. Mr. Smith, I encourage you and the committee to submit a favorable report on Senate Bill 337 to the General Assembly. So it's grown increasingly dangerous. It's not just about noise. It's mainly about the death toll that's taking place on Maryland's highways as we speak. That's not my opinion. The Maryland Highway Safety Office latest reports that traffic deaths jumped by 6% in 2020 over 2019 to 568. That's 3 people dying on Maryland roads every 2 days. That's bad enough, but it's even worse when you consider the significantly fewer highway miles driven in 2020 due to COVID. In Montgomery County, sir, the Vision Zero program just last weekend revealed a 34% increase in traffic deaths in 2020, not just compared to the previous year, but to a 4-year average ending in 2019. These numbers are headed in the wrong direction, and we're trying to find out why. So what we learned from current Maryland, from the officials that we're working with transportation police and other authorities across the state, that as Senator Kramer has articulated extremely well, current laws fail to effectively deter dangerous and illegal driving. Surrounding states are tougher. No Washington Nationals fan 6 years ago to this week missed the story that outfielder Jason Worth had served 5 days in jail after pleading guilty to reckless driving charge in Fairfax County. Quote the Washington Post. He was driving more than 100 miles per hour on the Virginia side of the Beltway. So Maryland needs to change its reputation from a roadways playground to that where safety comes first. We heard a feedback from, and working with the government staff and working across the state and in previous hearings, we heard feedback to the extent that, well, you know, in rural areas of Maryland, hey, what's a little problem with wide open spaces? What's the harm with a little extra speed? But the facts on rural driving do not support safety, Mr. Chairman, at higher speeds on rural roads. From an international mega analysis that the U.S. Highway Traffic Safety Administration has shared, the relation is very clear between, across a large number of studies. First of all, the higher the speed, the greater the probability of a crash. Second, at the same percentage increase in speed, the crash rate on rural roads increases more than the crash rate on urban roads. That's for the same speed. Third, the crash rate is also higher for an individual vehicle that drives faster than the other traffic on that road. So if you're by yourself in St. Mary's County or Allegheny County and you pass a couple, 3 cars, your rate of having a crash is higher than those other cars that are driving the speed limit. And finally, number 4, as the speed increases, the injury severity crashes also increases. So I agree. I'm not going to repeat Senator Kramer's point of view on the mandatory court provision, other than to say speeders should be made to tell it to the judge. Some say the 20 mile per hour reckless driving definition is too limited or tight. I say, our coalition says to that, pick your circumstance. Where you live with your children, perhaps in a 25 mile per hour residential zone, does 45 miles per hour in a single family or community, residential community, does a 45 mile per hour just deserve a shrug of the shoulders? Same thing in a 65-mile-per-hour zone. Someone zooms by you at 85 miles per hour, just another shrug of the shoulders. I think the 20-mile-per-hour threshold is reckless driving is certainly appropriate. So, Mr. Smith, we don't need more evidence. We don't need to try to interpret new graphs, data, and charts for next year while losing more lives. We need the will to put safety first in this session. So please embrace safety first in Maryland roads and favorably recommend Senate Bill 337. Thank you and your colleagues for your time and concern.
Thank you, Mr. Singh. I was actually going to ask you for some of those numbers, but looking at your testimony, it's very comprehensive, so I think it's good. Thank you very much for that.
Thank you. Thank you.
Okay, next we will have, I know Senator West, I've got your question, so don't worry, I got you. Colonel Anderson, you're up next.
Good afternoon. I'm Colonel Kevin Anderson, Maryland Transportation Authority Police Chief, and on behalf of the Maryland Chiefs of Police Association, I also chair the Highway Safety Committee. And we look at highway safety across the state, not just in Montgomery County, certainly not just in the Baltimore metropolitan area, everywhere. And both the senator and John are spot on. I get the opportunity to work with communities across the state, and they all say the same thing. What can we help you do to continue to enforce the laws that make a difference in these driving behaviors? Every one of these things has a common theme. It's driver behavior. Once we have a greater deterrence, we begin to change that driver behavior. Speed limits are exactly that. They're studied, they're looked at by engineers across the state. And once they're set for a purpose. The number of folks that are out on the highway to safely travel on our highways every day. Just in Maryland, we're trending the wrong way. As John mentioned, it's absolutely true. We've seen our vehicle miles traveled drop, but our fatalities increase. From 500 last year to 568 this reporting year of 2020. That's 68 more residents and travelers through our states who have lost their lives. And in the vast majority of that, speed has been a contributing factor. That's just unacceptable for us. We can do better. With your support, giving this a favorable report, we can have that deterrence that we need. And it does make a huge difference, other than a police officer just giving a citation that somebody can pay, to have to go into court and explain to a judge in this state why they felt it was need to do that behavior across our highways in Maryland. It's just not acceptable. Thank you.
All right, thank you very much, Colonel. We'll now have, so Mr. Townsend's not here. So Henry, Miss Henry.
Okay, first of all, thank you, the Honorable Chairperson, members of the committee. My name is Kenneth Henry. I am the mother of Natasha Pettigrew, who in the fall of 2010 was tragically killed by a drunk driver. And I strongly support this legislation. 10 years ago, I stood before this very committee pleading for stronger vehicular manslaughter laws, something that did happen. However, it is obvious that there is still need to do more, to send messages to potential perpetrators. 10 years, and I am still grieving because a drunk driver entitled herself to abuse the resources of the road, and further deemed that there should be no penalties for her reckless driving, nor the reckless endangerment of lives. And sadly, the statistics, as have been mentioned, are going in the wrong direction. They're trending in the wrong direction. Maryland transportation laws must require additional commitments to be overhauled, to be strengthened, and to be enforced. Commitments that may need to be two-pronged, as there may need to be greater support for public awareness and education. On a personal note, imagine that you just hugged and kissed your child, and 2 hours later, you are racing up a hospital corridor, only to learn that your child will die before sunset or forever be a human vegetable. One so full of life, how can this be happening? Imagine my horror when I discovered that this driver would get a $100 fine and a couple of points on her driver's license, yet she hitched and she left the scene. Drove 4.5 miles to her house, dragging my daughter's bicycle all the way. This is not just my journey, it's the journey of anyone who walks in my shoes. Because far too many motorists feel that they are entitled to get behind the wheel and do as they choose. Next steps. Next steps could be anything. However, continuing the advocacy for the implementation of stronger legislation, enforce the laws that are on the books. Also ensure that staff and employees get trained. Use them as ambassadors for your message. Commit to rolling out public awareness campaigns and education to include high school driver education. Make the penalties for failure to comply, as in failure to show up in court, more severe. Give them 250 hours of mandatory community service. Failure to complete will result in 10 days in jail. Second occurrence, take 250, add on 500 more. Failure to complete, 30 days in jail. And certainly I recognize that these are just recommendations, and all of which must be legislated and vetted through your legislative process. However, it may be time to think outside the box. Thank you so very much for this opportunity to speak to this body.
Thank you, Ms. Henry, for taking the time and for sharing your story. And sorry to hear about your loss. And so thank you for taking the time to testify today. And Senator Kramer, thank you for bringing this. I know I was wondering, I saw the video last night. I was wondering where that took place in the ICC. I thought it was the ICC. So that's incredible. I've actually seen things like that before on the ICC. And I do remember in Virginia when this happened, I think I was in either college or law school when they changed over and made it 20 over reckless, and the word did get out. So Ms. Henry, the word did get out, and they were successful in making sure that folks knew about that. Okay, so we have questions from Senator West and then Senator Casserly. So Senator West, you're up first.
Thank you, Mr. Chair. Senator Kramer, this is a great bill. And I'm so pleased that you brought it. I'm a little surprised that the Department of Transportation hasn't come before us with testimony on this bill. This seems to me that's right up their alley, and this kind of thing that you would hope state agencies would take a position on. I guess my only question, we just had a senator a couple of minutes ago say she was submitting legislation to increase the speed on the Washington Beltway to 70 miles an hour. And coupling that with your bill, it would mean that someone could drive on the Washington Beltway at 89 miles an hour, weaving in and out of traffic, and not be guilty of reckless driving. What do you think about that? I think we need to unmute Senator Kramer.
Yeah, thank you for that, Senator West. It's a very uncomfortable feeling, wanting to be able to speak and not being able to. No, thank you, and I appreciate your consideration and thought with regard to this. And I am not familiar with any proposal, so I did not hear this notion of raising the speed limit on the Washington Capitol Beltway to 70 miles an hour. That quite frankly is disturbing to me as someone who routinely has to use the Beltway. Traffic is already frightful driving on the Beltway, and when you have people who are exceeding the posted speed limit now of 55, it can be hazardous. So, you know, I would be distressed and concerned at the notion of being able to do that. And I don't know whether that's what you were looking for, an opinion with regard to, you know, that the prospect of that, but.
Yeah, now, your answer is very helpful.
My sentiment.
Thank you.
Thank you.
Thank you, Senator West. And Senator Casserly, you're up.
Thank you, Mr. Chairman. I'm looking at the fiscal note. It's really an interesting one. Sometimes these are boring and sometimes it's pretty interesting. And it's fascinating that they list the Exhibit 2 lists the offenses, and for people exceeding 20 to 30 miles an hour over the speed limit, you get a total of 13,000. People 30 to 40, almost 10,000. 40 miles and above, there's almost 50,000. So out of 70,000 tickets, 48,005 were for 40 and above. So I'm struggling at the 20. I'm struggling at the 20, Senator Kramer. But it seems to me, even if we up this to 35 or 40, my God, we'd be nabbing 48. I mean, that's to me, the 40 miles an hour above is just shocking. I know some people they're going 50, and next thing you know, they're going 70. It's a 50-mile-an-hour zone. But doing 40 miles an hour over just is shocking. It's that many of them. And I guess what I'm kind of, these folks are already, even with the prepaid penalty on the 40, on the people going 40 miles and above, they're looking at 6 points. So I'm not sure how much you can do this twice. I mean, you just got 6 points on this week. Next month, you're going to got 6 more points. It's not going to take long before you don't have a driver's license. So I'm just curious whether there's an enforcement problems here. That, I mean, are people not being, does anybody know? I get some of the law enforcement's involved. I had an issue last month where a constituent said, hey, I live beside the bypass coming through Harford County, and every day at a specific time, I can hear them drag racing out there. The very next week, I get a email from my state police superintendent saying, thank you for the tip. We issued 3 tickets out there for drag racing on your bypass, because it was like I think it was like Saturday evening or Friday night or something like that, I forget. And he'd do it. It's like within 1 week, he had shut that down. So do we have an enforcement problem where people don't want to stop folks? Because if you're going to get 6 points, that's 40 miles an hour. You just got 6 points. You get 6 points this week, next week, and next week. It doesn't take long before you're in jail, you've lost your license, and you can't drive that motorcycle or that car. What am I missing here?
Well, first of all, yes, enforcement is, and I preface my comments by saying a significant piece of what this is about. But the other part of it is modifying behavior. And you're right. It's a stop.
6 points is a lot of modification.
Well, but the problem is you can go 20 to 30 miles an hour over, and usually it gets knocked back. By the time you get pulled over and the police officer, says, all right, you were doing 40, I'm going to write you for 25 or 30 to move you down into the
well, that's what I was thinking, Senator Kramer. I was thinking the same thing, but then I looked at this table and I'm like, I'm figuring, they're going to all be down the 20s because, the officer's going to say, yeah, you were 40, but I'm going to back it down to 20. We got 50,000, nearly 50,000 tickets in fiscal year 2019, 50,000 of 70,000 for 40 and above. That's like, holy, and I know if it's 40, what they did? They bumped it down further. It probably wasn't 40, it was probably 60. Yes. So it's not like they're not issuing tickets on this. Look, I have no problem with nailing. I have the same fears all your witnesses did. I have kids and grandkids on the highway. I don't want people killed by these idiots. I'm just wondering what from the law enforcement folks, what do we got to do? Because I'm personally, I don't go that fast, but I would certainly be discouraged by the prospect of 6 points. I mean, your insurance just skyrocketed. You're talking big fines. Insurance is skyrocketed. One more time, you're probably going to lose your license. I mean, that's a heck of a discouraging prospect, but it's apparently not working.
Well, and that's because we need to modify behavior. And if you look at 20 to 30 miles an hour, it can be as little as 2 points, So we don't have people respecting, and that goes again to my early comments. People are looking at these speed limits as a recommendation as opposed to being the law. And that's why you see so many going 40 and above.
The guys in your video were clearly not looking at the speed limit at any level.
If I can, I'd like to commend Colonel Anderson because he has been exceedingly responsive across the state to this issue. And yet again, as I commented, I said, resources are limited. And unfortunately, when Colonel Anderson comes out, and they try to do something over a weekend in particular, they have significant outcomes. But then 2 weeks later, it's all cycling back over again. And unfortunately, the colonel and the rest of our law enforcement in the state don't have the resources to be out every day, every weekend, every evening enforcing. And so we have to modify behavior and get people to understand there's consequences. Right now, we just don't have consequences for the actions. And again, that's why everyone I spoke to on the law enforcement side of this, it just came right to Virginia has taken the right steps that have made a difference, have made a change. And in fact, as I also had stated, looks like they're pushing, we've got people who are moving into Maryland to race and do this because it is very serious in Virginia and they don't want to have the risk of getting caught there.
Well, let me ask Colonel Anderson, do you have any data on, I mean, we got 50,000 people here. Do we have any data on them other than the fact that at some point in 2019 fiscal year, they were doing 40 plus miles an hour above the speed limit? Or, I mean, do we know who these folks are? Anything about them? We're talking about changing behaviors. I think that would be a really relevant inquiry. Are these out-of-state people, in-state people? What are we looking at?
Sure, Senator, the answer is they're both. I don't have specific data in front of me. I can certainly pull that from the Highway Safety Office. The data that you have, as often that's where it's pulled from. And you're looking at that pre-judiciary. In other words, they didn't go in front of a judge. Some of them just prepaid. Some could have gone ultimately to contest or ask for a reduced sentence. And that does happen in a lot of cases where you do go to court, and you're absolutely right. Somebody may see that and say, oh, it was just 40 miles and over. So we can back that down to 35, et cetera, and make it a little bit different, because some of the judges, even when you go to traffic court, don't understand how severe this problem is. But by giving another deterrence where they have to start hearing this on a more regimental basis of how significant this type of speed is, and it's happening everywhere, should help us with that. And it really does start to change culture and driver behavior. And it's going to take some time. It's not going to just change next year, of course.
Well, of the 48,000 people total at the 40 and above, only 440 opted for a court hearing, 43,700 paid. So that is the final. I mean, they paid on a ticket for 40 and above, 43,700, and there's 3,800 are still open, which I guess means they disappeared or absconded or they whatever, God knows.
Right. And that's to the point is, if those folks are prepaying, they're really never coming in to sit in front of a judge and hear how damaging this is, not only to our state, but themselves as well. And if we have that extra deterrence, those more teeth into this specifics, I think you begin to see driver behavior change. And Senator Kramer's right. In other states, certainly our adjoining state, Virginia, it has made a difference. And anybody knows, you leave Maryland, you go into Virginia, you reduce your speed and sure you're doing the speed limit.
Well, Judge Morris, he's going to be here asking for more money because he's very pushes back hard when we try to get rid of any prepays. And this is 50,000 more court appearances in a fiscal year. So it's always a pleasure to see him. I'm sure we'll see him soon. Thank you. Appreciate it.
Yes, sir.
Thank you, Senator Castley. Next, we have Senator Hedelman.
Thank you, Mr. Chairman. Just two quick questions. One is I would like to hear, and we don't need to do it now, if you could get it to me, any other evidence that you have that this kind of approach has worked, like in Virginia, you said. And if, I mean, I can tell you my district and my house is right inside the Baltimore Beltway. And I have constituents and I have heard it myself, kind of like Mr. Sang said, the runway of the Baltimore Beltway. I mean, I have motorcycles and we've been in touch with the Golden Ring Barracks and they have, they've gone out there to try and enforce. So I know exactly what you're talking about and it's a big problem. I'm just wondering if, what other options are there out there to change behavior? And I just don't know if there's been studies about this that have demonstrated kind of what it takes to bring speed down or to change driving behavior. And have you done any kind of looking in social science research to see whether there are other approaches that work? Just curious.
To be quite frank with you, the answer to that is no. The recommendation, the bill that is before you is the recommendation out of multiple law enforcement agencies during the course of my meeting with them during the summer to discuss. And believe me, there were lots of different ideas put out, but the consensus was around this. Now, there will be a companion bill that you will be hearing, I believe it may be next week, to address some aspects of this racing piece of it. But the consensus was this is the action and the step to take that law enforcement felt would in fact make a difference and long-term begin to change behavior. And yes, there may be some empirical studies out there. I'd be surprised if there were, quite frankly. I'm not sure that there may be a lot of that, but this was the consensus across the board as to how, if we're going to try to get serious about addressing the issue, to go this direction. But thank you for the question.
Okay, thank you.
And by the way, if I just may add, and I'm not privy to your committee's written testimony, I will share with you that I did not receive anything from the courts taking a position on this issue. So if you did, I did not. It's very unusual for the court, if they have a concern, to not weigh in. So I do appreciate Senator Cassidy's comments about the chief judge of the district court, but I'm not aware that the court has taken issue with this legislation in any way.
Thank you, Senator Kramer. No, we are not in receipt of any testimony, but I suspect that will be forthcoming now that this conversation is percolated. Okay, thank you very much, Senator Kramer. And with that, that concludes the hearing for Senate Bill 337. We'll now move on to Senate Bill 179 with Senator Flossmeyer. There you go.
Thank you, Mr. Chairman and members of the committee. It's great to be here today. I almost walked up there and then I realized I just needed to be sitting here. So it's a little confusing sometimes.
Yep.
Senate Bill 179 authorizes state and local police to use this distracted driving monitoring systems and sets a framework for them to implement this technology. The problem of distracted driving is not new for any of us. And I think maybe I just heard a little bit about driving crazy during your testimony there. The General Assembly has passed various pieces of legislation to address this issue. However, with the limited resources that law enforcement has, it can be extremely difficult to enforce these laws. Statistics from the Maryland Department of Transportation indicate clearly that nearly 1/3 of vehicle crashes are caused by distracted drivers. And we've all seen them, and there's nothing you can do about it. This legislation allows state and local law enforcement to use distracted driving monitoring systems to assist in enforcing distracted driving laws. The legislation also sets up parameters for the use of the systems, including obtaining permission from local governing bodies and setting standards for how the information obtained by a camera can be used in court. With me today, I have John Pica and Bill Burley on behalf of Drive Safe Enforcement, who will go into further details about the type of technologies that can be used under this legislation. I also have Norman McCarthy, a victim of texting and driving accident, to express the importance of increased enforcement. I thank the committee for their consideration of Senate Bill 179 and ask for a favorable report. Thank you. And I have,
Thank you, Senator Flossmeyer.
yeah, so.
Mr. Chairman, may I?
Oh, there's John. Okay.
There you go. Pica, you're up.
Mr. Chairman, I'm sorry, thank you. John Pica on behalf of Drive Safe Enforcement, a Maryland headquartered business that has developed technology to enforce distracted driving laws. If you thought the last bill is going to save lives in the state, if you think the last bill will change driver behavior, this is a bill that will save more lives and definitely change driver behavior. I did check. So first of all, it's enabling legislation. It's not mandatory, and each county would have to approve whatever technology they saw fit to enforce distracted driving laws. So if you look at speed cameras and red light cameras, they produced about $64 million in revenue in 2018 in just 6 counties. So speed cameras and red light cameras, when they're employed, they reduce accidents at those intersections by more than 30%. So there is a way to change, actually it's 27%, pardon me. There is a way to change driver behavior and force people to begin to obey the law. In Maryland, there were close to 57,000 accidents last year. 31% of those accidents were caused by distracted drivers. That's up from 27% 2 years ago. It's up from 21% in 2010. There were 26,000 individuals in the state who were injured by distracted drivers, and almost 23% of those injured were passengers under the age of 9 years old. You're going to hear from a witness today, also from Bill Burley, who's a principal in the company. You have 4 other witness letters from individuals who were victims of distracted driving. I was not able to get Elizabeth Shaw or Elizabeth Marks here today. She wanted to, but she testified 2 years ago on this bill, or similar bill, and she's just having too many seizures, and she's in the hospital. So in the last 5 years, applications on your phone, apps, have grown almost 50%. So with Instagram and YouTube and Snapchat and Twitter and Facebook, and people taking selfies of themselves, you're going to see more and more driving accidents with people using their phones. Shock trauma treats about 7,000 patients a year. Most of those patients come from automobile accidents. They did not have a list of a number of how many, or the percentage of how many of those are from distracted driving. But the supervisor at Shock Trauma told me yesterday it is a substantial number and a significant number. So I know that Senator Sidnor had some questions a couple years ago on this bill, and there is a provision on page 12, I believe 12 and 13, that no party may share an image. So either the county is going to do this, or they'll contract with a third party. And there's a $5,000 fine if any image is shared that shows the identity of an individual, and they can only share, they can only send to the county an image of an individual with the face obscured, so that the identity cannot be, so that the person cannot be identified. So I'm happy to answer any questions at the appropriate time, Mr. Chairman.
All right, thank you very much, Mr. Pica. So we'll hear from the rest of the panel, and we'll take questions at the end. So next we have Mr. Burley. You're up.
Thank you. Good afternoon, Chairman Smith and Vice Chair and Senators. I'm William Burley, partner in Drive Safe Enforcement. I'm here today in the support of Bill 179 to present technology to accomplish that task. The victims and supporter of this legislation testified last year in the hearing of Senate Bill 819. I want to give you an overview of the unit. The vehicle, it's a mobile unit that is equipped with 6 to 8 cameras that stream video back to a processing software. When the driver sees a violation, hits a tag, puts a mark in the software to be reviewed later. At the end of the driver's shift, the file is downloaded and sent to be processed. Once it's processed, it's sent to the proper jurisdiction to approve or reject. The officer or agent will have log-on rights to their area and will review the violation to be approved or rejected. Once it is approved, it will move to dispatch and be sent out, violation will be sent out to the registered owner. The citation will consist of 2 to 3 photographs, one of the vehicle registration, one of the violator, and the video that was captured to prove that. If it is not approved, the video itself will be deleted. If it is approved, it will be stored for an amount of time or until the civil citation is paid or a court hearing is concluded. Here's a photograph of the current platform that we have, and you can see the computer on board there. The bill also calls for the scrubbing of faces, which has been implemented into our system already and ready for video processing before sending out for approval. Here's a snapshot of a gentleman who's in the vehicle, and you can clearly see his face there. Then the software scrubs it out in the second picture. Just like seat belts, red lights, cameras, and speed cameras, people need to change their habits, and this is one type of enforcement will help make that change and save lives. Please consider a favorable vote for this bill, and I thank you for your time.
Thank you, Mr. Burley. Next, we have Mr. McCarthy. Ms. McCarthy, you are ready to go.
It doesn't appear that he has a microphone.
Okay, understood. So Mr. McCarthy, we'll try to loop back with you, but let's move over to Ms. Carlson while we try to figure out some of the Mr. McCarthy's issues. Sorry, Ms. Biga, you were saying something?
Yeah, sorry. Ms. Carlson was not, she's a supervisor at Shock Trauma, and she very much wanted to testify in favor of the bill as she did 2 years ago, but she could not get out of Shock Trauma today.
Understood. Thank you very much for that. Well, with that, then that concludes the panel, and I'll open it up for questions unless we can get Mr. McCarthy's tech issue squared away, but let's keep it moving. So if the committee members have questions, go ahead and raise your hands. If not, we'll just ask.
They're not letting you unmute yourself.
Thank you very much for that.
Say something.
Can you hear me now?
I think Mr. McCarthy, you're live. And I'll open it up
Okay,
for
thank you.
questions, unless we can get
I'm sorry, can I get testimony now, sir?
tech issue squared away, but let's keep it moving. So,
Mr. I think you have the YouTube video going. If you could turn that off.
Okay, thank you.
They're not letting you unmute yourself.
Turn it off now.
Turn the, yes, Mr. McCarthy.
Can you hear me now?
Or mute it.
Try that.
Can you hear me now, sir?
Squared away.
Okay. Thank you. I appreciate your time, sir, and the consideration of this bill. My name is Norman McCarthy. I was involved in a crash on August the 25th, 2017 that changed my life. I was left with prolonged post-concussion syndrome after being rear-ended while sitting at a stop sign by someone who was distracted by being on their cell phone. Among my intense symptoms were dizziness, migraines, nausea, vertigo, sensitivity to light, and insomnia, and ended up being out of work for over 6 months. I was unable to drive myself, so of course my wife was driving me to different doctor visits. I was treated by one of the top neurologists, Dr. Shofi. She explored every avenue to try to relieve my symptoms, including using medication, treatments, and cognitive therapy. My business, which I have grown for over 27 years, was cut in half because of my inability to deal with daily tasks, which of course I still struggle with daily. As if losing everything with work wasn't enough, on September the 10th, 2019, during surgery, I lost my life. As a result, my heart stopped beating for 23 minutes. The doctors believe that was a reaction from the anesthesia that was administered. I had pulseless electrical activity that stopped my heart for 23 minutes. A code blue was called, and the protocol didn't really work. Luckily, I was intubated, so I had brain activity. So they continued to work on me for several minutes, which was over 20 minutes. Fortunate for me, I had a resident doctor, Dr. Gould, who was in on the surgery with Dr. Astorian, who didn't give up on me. He got my heart working again. With that being said, I'm very fortunate, but I still struggle every day. I'm struggling right now at this meeting because I'm confused with so many things with the computer. I had to have my wife get rid of the YouTube, get rid of this and that. And it's just, I'm back and forth. And to give you people have to go on with their daily life. I struggle with my daily life every day. Just in listening to things today, I'm still trying to get Casey Kasem out of my head for the last 3 days for the top 40.
So it's kind of hard to deal with brain issues and try to understand that the crash was one issue. The gentleman that hit me only had a $25,000 policy for personal injuries. My first surgery was over $30,000. I'm still struggling because I have to pay all that out of pocket. My insurance won't pay it. I have lawyers that are involved that I didn't want to do. It's ongoing. And earlier they said something about the driver behavior. We better wake up because it's kids that are getting into these cars now that have a habit with cell phones. They're addicted. If you can't see that, I mean, it's just a bad combination. But again, with myself, we look for you leaders for our public safety. And I don't know if any of you know anybody that's had an issue with somebody being hurt for distracted driving. But it doesn't just end at that accident. It doesn't end when you get out of hospital. Again, I'm 64. I was looking forward to retirement. I've lost half of my savings just dealing with doctor bills and just struggling with daily life. So thank you. And I appreciate your time.
Thank you, Mr. McCarthy, for taking the time to testify with us today. And glad we got your tech issues figured out. I guess you're muted. And we have your written testimony as well. So thank you very much for that. And with that, that'll conclude the hearing for Senate Bill 179. Thank you very much, Senator Klossmeyer. We'll now move on to Senate Bill 317, Senator Heddleman.
Thank you very much, Mr. Chairman, members of the committee. Good to see you all. We're going to pick back up with immigration issues that we started with this morning with the chairman's bill. This is this is Senate Bill 317. And this bill is about universal representation. And I would thank you very much, Sandy, for bringing up the PowerPoint. You can go to the next slide, please. People who are facing deportation aren't provided lawyers to represent them. I was actually surprised to hear this, thinking because they are detained and because they're losing their liberty, that this may be something that would be covered under the Sixth Amendment and a right to effective counsel, but it is not. Indigent citizens, non-citizens aren't provided attorneys to represent them, even though they are facing that loss of liberty and potential deportation, permanent separation from family, especially children who may be U.S. citizens, the loss of liberty through detention in jails and detention centers, and the very real fear that if they are returned to their countries of origin, that they will be killed or tortured because many of the reasons that they left their countries of origin was because of a fear of being persecuted. Next slide, please. For many, many people, and we know this because there are programs, 40 plus, I believe, around the country that do provide universal representation. Legal representation is the difference between winning and losing a case in immigration court. Those with representation are significantly more likely to win their cases. And there are studies that demonstrate that they are 10 times more likely to win their case with a lawyer. As we saw earlier, and as we've seen in other hearings that have been before this committee, immigration laws are very complex, even for trained attorneys. For many of the folks who are detained, it's really unrealistic for them to be able to mount a defense for themselves as a layperson. Many of them, English is not their first language, and all of the information is provided in English. And detained people don't have access to evidence or the ability to really gather material for an appropriate defense. What we also know is that benefits of representation include the resolution of cases more quickly and reduced time in detention. Next slide, please. In Baltimore and in Prince George's County, there are services that are provided by the local government to the services, representation services to people who are being detained. And in the Baltimore Immigration Court, there was a study that demonstrated that individuals with representation were 4 times more likely to win their case. Unfortunately, 80% of the 81% of the detained immigrants in Maryland had no legal representation at any point in their case. And of these, only 7% of those detained in the Baltimore Immigration Court won their case without representation. Next slide, please. Then that is really why the right to counsel on immigration proceedings is so important. We believe that all people, regardless of their income, background, or the kind of case, are entitled to this kind of due process under law. And that kind of due process is really unavailable without an attorney. This bill would ensure that government provide those lawyers to people who can't afford them, just like the public defender office. And I should tell you that you don't have them before you, but we are, next slide, please, going to be offering an amendment to change the main entity in this bill from the Attorney General's office to the Office of the Public Defender. So please keep that in mind, and that will be a theme throughout this hearing. So what does the bill do? Next slide, please. It ensures that this due process is provided to people who are detained and indigent Maryland residents facing deportation, and it ensures that they are provided legal representation. The Office of the Public Defender will coordinate the services, they will host the program, and as well as provide some representation. For those Marylanders that are detained out of state, because we know that some, even some of whom are picked up in Maryland, sometimes they are deported to other detention facilities, whether that's in York, Pennsylvania, or in Virginia, or sometimes even in Georgia. This legislation will also help them obtain an attorney in that state where they are being detained. It also provides outreach and support for detained individuals and their families and their communities to give them information about what other resources are available in the community to help support them throughout this process. Next slide, please. So how many people are we talking about? We know that there are roughly 530 individuals who are in need of representation each year. And those are people who are in detention proceedings, they are detained and they're unable to afford counsel. Roughly 400 of those are Maryland residents who are facing deportation proceedings within the state, and roughly 130 are being detained, as I said earlier, in facilities that are outside of the state. Next slide, please. So here's some data about some of the state's non-citizens. We believe that just under 60% of the residents, or about over 300 individuals, will likely win their case if represented. And this would save Maryland employers, because these are people, many of whom are part of the workforce now, an estimated $1.7 million annually in turnover costs when their employees are saved from deportation. And this also has an impact on Maryland's GDP. And we estimate that it would be about a gain of over $16 million for the state just this year. After 10 years, that's a big chunk of money, just under 180 million for full representation statewide. We believe the total cost of the program is in the neighborhood of $6 to $8 million to represent 530 people per year. Next slide, please. Right now, as I stated earlier, there are two programs up and running in Maryland, one in Prince George's County, one in Baltimore City. The Immigration Services and Language Access Initiative that works closely with the CARE Coalition and Prince George's County provides legal representation to detained individuals from Prince George's County. And the county has also put in $500,000 of their own money to run that program. In the city, the Vera Institute of Justice's Safety and Fairness for Everyone Network seeded the program there with $100,000, and $100,000 is going from the Baltimore City government for that kind of representation as well. Next slide, please. And these programs are successful. Here's what we know about the Baltimore City Right to Counsel program. In just 1 year, 38% of the cases represented by attorneys were successful in their outcomes, allowing clients to remain in the US. And these are people who are asylum seekers. Some of them are longtime legal residents who are part of our workforce, as I said earlier, parents and spouses of US citizens, and people who came to the United States as children. More than a third of them came to the US as children. Almost 80% of them are breadwinners in their families and responsible for at least half of the family's income. And by the end of the first year, 41% of the detained clients were released from custody, either freed on bond or won their cases outright. And I think what this demonstrates is that they have a good defense. They just don't know how to mount it, and they need the expertise of legal representation to help them do that. Next slide, please. So what we also know is about a quarter of the SAFE clients have been identified by their lawyers as possible victims of crime, domestic violence, intimate partner violence, or human trafficking. And for clients who are women, the stakes are even higher, with 41% of them identified as potential victims. 67% of the SAFE network clients who have filed applications for relief are pursuing protection-based claims, meaning asylum or withholding of removal or seeking relief under the Convention Against Torture. And again, this goes to the idea, and I think the real important assertion, that many people who are here because of spiraling situations in their home countries and fear of a well-founded fear of persecution. Next slide, please. Okay, so I think we're back to the beginning. One of the things that I did not get to talk about in that PowerPoint presentation is the bringing the voice of the people that this affects. And in your written testimony, there are quite a number of documented experiences from people who are living with these issues. And one I want to call to your attention in particular, and this is a woman by the name of Ana Benitez. Her husband is currently being detained. He was arrested a little over a year ago in December of 2019 and has been separated from his wife and his 8-year-old family since then. She was able to afford about $6,000, 2 months of representation, but had to stop because she couldn't afford it anymore. She didn't have any more money. And she believes that her husband is eligible for asylum. Many of his family members were killed in El Salvador, causing him to flee to Maryland. They don't have a lawyer to help get him released or to help him mount the defense that he needs. And during her pandemic, unfortunately, her husband got COVID and while he was detained. And this is one of the important reasons I think that we need to act this year on this, is because there are so many immigrants in detention who are suffering and facing life or death situations while they're behind bars in detention. So I have a wonderful panel of great experts who can help address some of the issues that may come up, but I would love to turn it over to Eric Lopez from CARE.
Thank you very much, Senator Hedelman.
Thank you.
Mr. Lopez, you're up. Hold on, Mr. Lopez, if you click go ahead and ask to unmute you there. There you go.
Thank you. Good afternoon, Chairman Smith, Mr. Vice Chair, and members of the Judicial Proceedings Committee. My name is Eric Lopez. I am a managing attorney at the Capital Area Immigrants' Rights Coalition. That's the CARE Coalition. And our organization is a legal service provider that focuses our representation on detained non-citizens, detained immigrants here in Maryland. I've been representing detained immigrants myself for a little over 5 years. And I'm here to testify in support of SB 317. So why provide attorneys to detained non-citizens, to detained immigrants? Well, it's exactly precisely because of what is at stake in this system. What is at stake is the potential loss of liberty, right? The banishment from one's home, and the potential permanent separation from one's family. Deportation is tantamount in many cases to a death sentence for those deported to countries that they fled fearing for their lives. Now, civil immigration proceedings, again, do not trigger those Sixth Amendment rights to counsel, right? There's a statutory rights to counsel in the immigration law. However, what an attorney is not afforded, is not provided at the government's expense. Now, this is significant because even though the immigration system is civil in nature, and is defined in terms of a civil proceeding, it is almost indistinguishable from criminal proceedings. Non-citizens in these proceedings are jailed in the same jails as those facing serious criminal charges. Individuals are chained, their hands are chained, their feet are chained in open courts as they appear before an adjudicator to hear their immigration claims. And then these individuals must navigate a complex web of immigration law in a language that is not their language, and also are held to the standard where the burden is on them to prove that they merit and deserve relief from deportation. Now, why again provide these immigrants and non-citizens representation? Because it matters, it is effective, and it is the opportunity here for Maryland to step up to the occasion and protect Marylanders and their families from the harsh and punitive consequences of immigration detention and deportation. SB 317 is also a racial justice bill, right? This bill combats a systemic racism in our criminal justice system that translates into and trickles over into our immigration civil proceedings, a system that disproportionately targets people of color, where individuals are overcharged, overcriminalized, overpoliced, and then have to bear those consequences in their immigration proceedings. That is also why SB 317 is just as important to pass as the Trust Act, SB 88, because it creates a safer home for Marylanders who reside here within the state and who call this place home. Now, why create a statewide legal representation system? Well, as Senator Hettleman pointed out, we do have two local examples here in Maryland that are in effect and that are successful and that lead to successful outcomes. Baltimore City and Prince George's County are excellent examples here locally of how this system can succeed and operate, and why it is crucial to have those similar systems in effect statewide. Now, the statewide system is critical because while Baltimore City and Prince George's County funds deportation defense for those detained, it is jurisdiction specific. I have had to firsthand deny representation to non-citizens and immigrants in need who happen to live across the city limits, right? Or across the Prince George's County limits. This SB 317 and creating a statewide system is part of a greater national movement that is taking place, right? With 6 other states also providing deportation defense statewide, and with over 41 jurisdictions nationwide also local governments funding this type of deportation defense. There's a Vera Institute of Justice polling survey that came out this year that shows that there is overwhelming support for providing government-funded legal representation in immigration proceedings across the political background, irrespective of loyalty to political party. Now, I'll highlight what's really at stake here. I've already mentioned the kind of systemic ramifications of what this is. Let's bring this home, and let's remember Ana Benitez's testimony, Claudia's testimony earlier today. Families who have had husbands, brothers, siblings, and parents deported and separated from their lives. I can think of a client of mine who I was able to obtain a green card for, and where he was able to leave detention and meet his infant daughter for the first time. That is the impact of legal representation and affording an individual in ICE custody legal representation, because it leads to outcomes that have ramifications for generations of Americans to come. Lastly, while the Biden administration will most certainly have a more humane tone and humane policies for immigration, they cannot unilaterally solve a broken immigration system. Maryland can act here and step in to protect Marylanders and their families. Thank you so much for your support for SB 317. It is a critical moment in our history to pass this bill.
Excellent. Thank you very much, Mr. Lopez. Next, we'll hear from Mr. DeWolf. You're up.
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. My name is Paul DeWolf. I'm the State Public Defender. The Office of the Public Defender is honored to be designated as the coordinator of the Maryland Rights Council in immigration proceedings established by Senate Bill 317. It is estimated that 600 Maryland children per year are at a substantial risk of permanent separation from their parents due to ICE enforcement actions. Parents are held in ICE custody in Maryland jails with no viable opportunity to post bond. Many ICE detainees have decades of work history in Maryland and extensive community contacts. Having a U.S. citizen spouse or a U.S. citizen child does not prevent ICE custody or deportation. It is nearly impossible to win a deportation case. 95% of cases were successful when the immigrant was represented. It is important to note that this program would only serve indigent Marylanders who are not otherwise represented by counsel. OPD, Office of the Public Defender, acting as coordinator of the program, will assign indigent detainees cases to designated organizations whose staff have the expertise and the demonstrated capacity to provide high-level representation to these vulnerable individuals. The Office of the Public Defender's Immigration Division already works with the CARE Coalition, CASA, and other community groups to help our clients. The Maryland Office of the Public Defender is the appropriate entity to be the coordinator of this program. I notice that the bill designates the Attorney General's office. I spoke to the Attorney General before testifying today, and their office neither has the capacity nor the infrastructure to coordinate this program. The Office of the Public Defender has the client-focused infrastructure, long established functioning throughout Maryland. Our staff work daily in prisons throughout the state. Unfortunately, few private attorneys are willing, capable, and financially able to represent ICE clients. Immigration law is extremely complicated, often being equated to tax law. Deportation defense is a subspecialty requiring even more specialized expertise. Practitioners have intricate knowledge of numerous bases for deportation, case law interpretation, asylum case law, and other details of other defenses to deportation. Few private attorneys find the field is practically or financially feasible, especially adding the extra burden. To meet the needs of these and provide high quality representation, the Office of the Public Defender will assign indigent detainees to these designated organizations. The Maryland Office of the Public Defender does not currently represent individuals in immigration proceedings or deportation hearings. Under the obligations, though, imposed by the Supreme Court case of Padilla versus Kentucky, we do provide individualized advice to our immigrant clients of the immigration consequences of their criminal charges and convictions. This is where our services end, however. The result is that our former clients are left on their own in immigration court. ICE is represented in each case by an experienced attorney employed by the U.S. Department of Homeland Security. A few fortunate detainees are represented by the CARE Coalition under grants and similar programs from PG County and Baltimore City, but the vast majority lack counsel in these quasi-criminal proceedings and remain in jail throughout the deportation hearings. The Maryland Public Defender's Office is the appropriate entity and is highly capable to be the coordinator of this program with additional appropriations beyond our current budget. And for these reasons, the Maryland Office of the Public Defender strongly urges a favorable report on Senate Bill 317. Thank you.
All right, thank you very much. Next, we have Ms. Dornell.
Yes, I'm here. Good afternoon.
How are you? Good.
I'm doing well.
doing even better if I could figure out how to start my video. Good afternoon, Chairman Smith, Mr. Vice Chair, and members of the committee. My name is Lisa Dornell, and I am a retired United States immigration judge who served at the Baltimore Immigration Court for almost 25 years, during which time I presided over hundreds of cases. As a former immigration judge and as a longtime resident of the state of Maryland, I am proud to support a bill that would provide appointed counsel to people in immigration court proceedings. My colleagues on the bench and I have seen firsthand how, without legal representation, non-citizens face the prospect of deportation. And as Senator Hettleman and Mr. Lopez pointed out, they face possibly a permanent separation from their Maryland families and communities. The reality is that immigration law has become increasingly more complex. I had law clerks to assist me with legal research and legal analysis, but what about the unrepresented? As an immigration judge, I was acutely aware of the imbalance that was just described in court proceedings, where non-citizens who were unrepresented had to face that trained lawyer from the Department of Homeland Security. It was a situation that felt as jarring as it did unfair. While as a judge, I was able to advise unrepresented non-citizens of apparent relief from deportation, the law did not permit me to advocate, because that is not the role of an independent arbiter. There is simply no adequate substitute for appointed legal counsel. Immigration judges are in a unique position to assess who is deportable or not, and who might be eligible to remain in the United States or not. But we cannot make decisions on applications and arguments that are never raised to us. And the presence of appointed legal counsel for all ensures that all pertinent facts are presented so that every case can be fully and fairly considered. In my experience, the presence of legal counsel promoted fairness and efficiency. And I'm sure you're all familiar with the saying that justice delayed is justice denied. Well, appointed counsel in these cases would mean that cases would be ready for trial as scheduled without the delays that result from repeated requests from the unrepresented for continuances so that they can find a lawyer to help with their cases. This one bill represents an opportunity to enhance the promise of due process of law, to mitigate the effects of over-policing and over-prosecution of Black and Brown members of the community who are disproportionately funneled into the immigration system. This bill provides an avenue through which we can protect family relationships of our residents of Maryland and their United States citizen family members who get left behind when non-citizen husbands and fathers and wives and mothers are deported. Thank you for this opportunity to be heard.
All right, thank you very much. We'll now turn on to Mr. Dollimore.
Thank you. Good afternoon, Chair Smith and members of the committee. My name is Matthew Dollimore, and I represent Catholic Charities as director of the Esperanza Center. Esperanza provides comprehensive immigration services in the Baltimore region that includes humanitarian legal services, English language instruction, case management, and free primary medical and dental care for the uninsured. I'm here today in support of SB 317 with amendments. We are fully supportive of the sponsor's amendments and believe it is prudent to house this program within the Office of the Public Defender, as they are the experts on statewide intake and have locations throughout the state. Our work at the Esperanza Center is guided by Catholic social teaching, which emphasizes the inherent sacredness of each individual and family. We welcome our new neighbors and support them to live full, safe, and dignified lives here in Maryland. To offer an anecdote, after 4 years of litigation, which started in 2016, a team of Esperanza Center attorneys won asylum on behalf of a client in Baltimore Immigration Court. That client had come to the U.S. as an unaccompanied child who fled gang violence in Honduras. Initially, the asylum office had denied that client's claim. But upon de novo review of the client's deportation proceedings, and due in large part to legal representation provided by Esperanza, in 2020, the judge granted asylum. Following 4 years of dedicated representation, provided at no personal cost to that client, they permanently found their safe haven here in the United States. The consequences of detention and deportation are serious. Family separation leads to lasting trauma and hardship on remaining family members and on our community's social fabric. The U.S. Supreme Court recognized in a 1922 decision that deportation, and I quote here, "It may result in loss of both property and life, or of all that makes life worth living," end quote. Just as we provide representation in a criminal law setting, we are morally called to provide it for those civilly detained here in Maryland. Thank you for considering our views. I urge a favorable vote on SB 317. Thank you.
All right, thank you very much. Next, we have Corey Lazar.
Good afternoon, Chairman Smith and members of committee. I'm Corey Lazar, Senior Program Associate with Vera Institute of Justice's SAFE Initiative. I'm testifying in strong favor of Senate Bill 317 to establish a funded legal representation program for Maryland residents facing deportation. We also submitted testimony in support of Senate Bill 88. As you've heard today, with no federal defender system for people facing deportation, most people, including an estimated 70% of people in detention nationwide, stand alone in immigration court against highly trained government attorneys seeking to deport them. Vera's SAFE initiative is a nationwide collaboration among governments, immigration legal service providers, and advocates working together to build a movement for universal representation so that everyone at risk of deportation can have access to legal representation. In Maryland, Baltimore, and Prince George's County were two of SAFE's first partners in 2017, pioneering representation programs and keeping families together. Recent polling shows these programs are widely supported by the public. Especially now during the pandemic, the need for representation is greater than ever. Conditions inside facilities create high risk for all those who are held there, who work there, and for the surrounding communities. ICE's continued arrests and bookings undermining communities' efforts to stem the spread of the virus. So more than ever, representation can mean the difference between life and death. Immigrants who are represented are 3.5 times more likely to be granted bond and up to 10 times more likely to win lawful status in the United States. Representation programs, as well as the proposals in Senate Bill 88, are also critical to addressing systemic racial injustice by interrupting an arrested deportation pipeline that leads to racial profiling and criminalization of communities of color. Jurisdictions across the country this year have started or expanded deportation defense programs. This includes the state of New York, New Jersey, Illinois, and a new program established in Harris County, Texas. Maryland has a critical opportunity to continue leading this growing movement for universal representation and paving the way for federal change. While the Biden administration is taking encouraging steps, the radiating impacts of mass detention, separation, and deportation require transformative change, only possible with dedicated legal advocacy, local and state program support. So we urge the committee to report out Senate Bill 317 favorably. Thank you.
Thank you very much. All right, so that concludes testimony for the proponents. Now I'll switch to the opponents. We have Ms. Rendall.
Thank you, Chairman Smith, and thank you other members of the committee. My name is Sherry Rendell. I'm the Director of State and Local Engagement at the Federation for American Immigration Reform, and I urge you to oppose this legislation. This bill to provide taxpayer-funded legal representation to illegal aliens undermines federal law. Federal law expressly prohibits governments from funding legal representation of aliens in removal proceedings. Aliens who wish to obtain counsel are free to do so, but it says that they should not be paid for at taxpayer expense. I've heard many today compare these representation to criminal representation. The Supreme Court has ruled that the deportation of an individual is not a punishment, but rather a civil administrative procedure that is where somebody residing illegally in the United States is returned to their own homeland. Moreover, providing counsel at taxpayer expense to those residing illegally is patently unfair. Taxpayer-funded legal representation is generally unavailable to citizens or legal immigrants who face civil proceedings, i.e. Foreclosures, evictions, divorce, child custody, and even non-criminal administrative disputes, such as disagreements over taxes. They have to pay for those proceedings out of pocket. Those who are residing illegally in this country should not be obtaining free representation. There are many nonprofits here that have testified that there is already those nonprofits who are providing this legal representation. It shouldn't be done at taxpayer expense. Moreover, this is a way to advance a politicized agenda instead of directing resources to the needs of the community as a whole. It promotes welfare rights for those who are here in the country illegally, those who are violating federal law simply by being in this country. In the middle of a pandemic where thousands of Marylanders are struggling economically, this legislation is a drain on the state's ability to help the needy. It will also encourage additional illegal immigration, thus further straining already limited resources. SB 317 tells Maryland residents that certain segments of their population are more important than others and are entitled to special privileges. It is for these reasons I urge that you oppose SB 317. Thank you.
All right, thank you, Ms. Rendell. And next we have Mr. McAvoy. Looking for Mr. McAvoy, but Senator West, what's going on?
I have a question when the time comes.
Okay, got it. All right, we'll keep that in mind. You're first in the queue.
Okay.
All right, so now I don't see Vince, so we're going to move on to Mr. Tu. How are you? There you are.
I'm good. Thanks for unmuting me. I'm actually jumping around between this bill and House Bill 15, so it's kind of happening at the same time. So I see a lot of familiar faces. Hope everyone's doing well during the pandemic year. Good to see you again, Mr. Chairman. So I'm here to testify against the Senate Bill 317. Let me open up. So before I state the reason, I want to appreciate you guys giving me an opportunity to wear my Maryland tie for the first time this year. And, you know, it's a tough year and we just try to be uplifted at this time. So the reason I come here to testify against Senate Bill 317 is I feel like we should not use public money to support illegal immigration, regardless of our personal opinion on this illegal immigration, because it's going to send a really, really wrong message that I believe lots of committee members are lawyers, and you guys, this is your profession. And the reason you jump into this profession is to uphold the law. And immigration law is the federal law. And what this bill is doing is use state of Maryland's taxpayers' money to actually support illegal activities. So I myself came to the United States as a graduate student 25 years ago. After that, we decided to permanently live in this country. And my wife and I spent a good fortune actually to get legal assistance in order to file all this paperwork to get a green card or be naturalized. And we follow every simple step of the law and regulation and wait patiently in order to get the permanent resident status. It is simply wrong to use public money to fund illegal immigration. So having said that, I am also strongly believe that illegal aliens having right to defend themselves with or without legal representation. And this kind of assistance should be from private fund. For example, if Casa de Maryland wants to use their private raised fund to defend illegal immigration, feel free to do so, right? Or whoever sponsor this bill or vote for this bill want to use their own salary out of their own pocket to help defend illegal immigrant. I have no issue with that, right? So my issue is do not use public fund to actually support illegal activities.
Time.
Any questions?
Thank you very much, Mr. We so that you are the last witness, and so that rounds out the opposition panel. We'll now turn to the committee for questions, and Senator West, you are up first. I've just asked to unmute you. There you go.
I've now unmuted myself twice. Hope that's enough. So
that may be a sign. I don't know. I'm kidding.
Thank you, Mr.
Kidding.
Chair. So it's an interesting bill. I've long been in favor of the state providing legal representation to people in the state who are unable to pay for it. The problem has always been, how does the state pay for it? Because legal representation is extremely expensive. So I'm looking at the cost of this, and it looks like it costs $6 million annually, plus the staffing costs of about $250,000 annually. So Mr. DeWolf, you're in the Office of Public Defender. Apparently there's going to be an amendment to change this bill so that you will be responsible for hiring staff and for paying these expenses. Have you received any assurance from the Office of the Management and Budget or from the governor's office that he will increase your budget by this amount of money?
No, Senator West, I have not.
As I understand your budget, you're already strapped. Over the years, I've been involved in the Bar Association, and we keep hearing from Office of Public Defender that it's really, really, operating on a shoestring. Do you have an extra $6 million in your budget that you can devote to this?
We are constantly underfunded, and we continuously come to the legislature and to the governor's office for additional funds. However, this bill, I think, is important because we already represent a number of these individuals in criminal court. We provide them with advice on the consequences of the immigration consequences of the criminal conviction. And then they're left to themselves when they go to immigration court. We have a small staff of immigration attorneys, and we collaborate with the CARE Coalition and other community groups to try to assist these individuals when they, having been given advice and having been helped through criminal court from our office, we do what we can to coordinate with the other community groups so that they're represented. But as been already testified, if you don't have a lawyer, 95% of the cases that are won in immigration courts are those cases in which the individual has an attorney. So this bill would just would fix that. In terms of the staffing, I think the fiscal note was about $181,000 for 3 staff members, which is a significant amount of money.
For the first year, but I think that's part of the year. The fiscal note goes on and says in the future years it's going to run in the range of $250,000 a year.
I don't dispute that, but given the cost to, I think we mentioned 600 potential children that would be left without a breadwinner, I think the cost to the state is advisable or at least reasonable.
Well, I'm really not focusing on that. And apparently there's no commitment from the governor to add this money to the public defender's budget. So my question is, within the confines of your existing budget, in order to provide these to provide grants to lawyers who are experienced in this area, it is a very narrow area requiring narrow expertise. In order to pay for those grants, it's going to cost you, in round numbers, $6 million a year. That's $6 million you will not have for your other activities unless someone is prepared to increase your budget by $6 million. So how would you expect to pay for this?
Well, I don't dispute the amount because I wasn't involved in the drafting of this, the fiscal note. Our responsibility will be to coordinate the program and to make the referrals. The money for the referrals would pass through the public defender's office. And you're right, Senator, it would have to be separately funded, but it wouldn't come out of public defender funds. It would pass through our office to the entities or to the attorneys who would provide the representation.
So the bill, as I read it, that doesn't provide for a mandate. So there's no requirement that the governor's, the Office of the Budget or the governor put this in, for example, in next year's state budget. Even if it were mandated, it could be put in the BRFA and taken out of the budget. But irrespective of whether there's money, it looks like you're required to provide these services. So and my question is, if the money is not forthcoming from the state, how would you provide these services?
We'd just provide the coordination. So we would refer to the community organizations to the extent that they could pay for it. But I don't disagree that there will be needed significant funding to add to the various budgets of the community groups like Care Coalition who provide the direct representation. It's not anticipated that we would provide the representation. We would pass the money through to the other organizations. But Senator, I don't disagree that it would require significant additional funding.
Okay, let me go back then to Senator Hedelman and ask some questions of her, if I could. Senator Hedelman, in line with my earlier colloquy in connection with that earlier bill, I have no problem with assisting immigrants who are lawfully pursuing the American dream. I do have a big problem with subsidizing or helping immigrants who have committed crimes, especially violent crimes, and want the public to pay for their continued residence in this country rather than their being deported. So I see nothing in this bill which would separate out people, for example, who have committed murders on the one hand, or people who have just been apprehended and there's an effort to deport them on the other. Is it your intention that the taxpayers of Maryland will be expected to pay for legal assistance for people who have been apprehended and are being tried for murder in this country, and deportation as a result?
Thank you for the question. And the bill does not discriminate on the basis of why someone is being detained. So it would apply across the board. But I think that's probably a better question for Mr. DeWolf, since I think that's part of our constitutional responsibility anyway, is providing representation to people under the criminal law. Am I right?
Well, Mr. Wolf,
we provide representation under the Sixth Amendment for the criminal charge, and under Padilla versus Kentucky, we're required to provide accurate advice on the consequences of the criminal conviction to the immigration status. I hope that answers.
So my understanding is, right, so they would get advice from the Office of the Public Defender on that criminal charge and go before court. And if indeed they were held, were convicted of a crime, then they would be deported. And
well, no, if they were convicted of a crime, the government would try to deport them. And under this bill, the state taxpayers of Maryland would be required to provide them a lawyer to fight deportation, correct?
Well, not necessarily. I mean, I think part of the representation process is to advise a client that they may well be deported under federal law, and that's it. Again, I think that part of what the role is of an advocate is to let people know kind of what the chances are. There are substantial costs to an appeal, that would be borne by the defendant, my understanding is, and maybe Mr. Lopez can respond to this, but that's my understanding is it's pretty risky to do that because I think they then bear the costs of that bond if they.
Well,
if
I'm
they
looking
should lose.
at the language of the bill on page 3. It says covered proceeding means a judicial or administrative proceeding where a covered individual is subject to removal from the United States.
Right.
So if someone someone is an illegal immigrant, is convicted of murder, and now the federal government is trying to deport that individual, as I read this bill, it requires the state taxpayers of Maryland to pay for a lawyer to defend that person in the removal action. Am I wrong on that?
I think you're right on that. But what I'm also saying is that it may not necessarily be that they are then going before the court. It may be that they are going the meeting with their defendant, with the defendant to say, you know, we're kind of, this is the end of the road here and you're going to be deported. But I would like to pass this on to Eric since he is actually represented people in those situations. So if I could do that, he can probably better respond to your question.
Well, it really was a cost question, but go ahead, Eric. Can you add some light in this area?
Needs to be unmuted.
We need to unmute Eric Lopez.
I am doing that right now. Here you go. Mr. Lopez, there you go.
When I write my memoir, that will be the title of it. We need to unmute Eric. But yes, thank you, Senator Hedelman. Thank you, Senator West, for letting me address this. So look, this bill, it doesn't exactly, it defines what the scope of representation is, what mechanisms under the Immigration Act and proceedings are covered. The Immigration Act itself is incredibly harsh and punitive against individuals with serious criminal convictions like the ones that are criminal offenses like the ones that you're highlighting, Senator West. Now, in terms of someone unjustifiably exploiting legal representation to challenge deportation, simply the Immigration Act does not allow that. And the efficiencies that are introduced into the system by having legal representation is actually one of advising the individual who may have committed a serious offense that they don't have a means of relief, that the only possible outcome here is to simply be placed into deportation. Now, where this is efficient is having the legal representation to, one, know that, two, advise the individual that, encourage the individual to accept that legal advice, and then help the individual actually facilitate the deportation, working with DHS to get that individual out of the United States as quickly as possible, reducing costs of prolonged detention. In terms of the cost of appeal, Senator Hedelman, you're correct. I mean, there are fees and fines associated with trying to litigate these cases. The efficiency of having legal representation here that is injected into the system is immense and great. And I believe Judge Dornell, who spoke earlier, I think can shed some light in terms of the value of having legal representation, even where one would not have a means of actually having a viable challenge to that charge of deportation by the government.
So let me go to my next question. I can't find anything in this bill where there's a means test. It looks to me as if you've got like one of these criminal gangs, which has made itself rich from feeding off of the American people, and they've got all the money in the world, and one of their members gets arrested and is in the process of being deported, that person, despite his ability to pay for legal representation, gets it provided free by the state of Maryland.
So we realize that also, and what I would do in the amendment process is to tie that to the eligibility for representation by OPD. So I think that's yeah, I agree with you actually.
And that was consistent with my testimony too, Senator.
Okay, and then I got two other questions. First of all, this idea that we're going to pay for legal representation in other states. So let me get this right. So an illegal immigrant has come to Maryland and is now established legal residence here. And now he moves out to Idaho. And before he establishes legal residence in Idaho, he commits a murder out there. This bill requires Maryland to pay for an Idaho lawyer to represent this guy out in Idaho on the murder charge and the associated deportation charge, correct?
Well, it's not the associated deportation charge. That's not covered here. But
I
I think
thought that was what was covered. As I read it,
it's the representation, it's not the,
covered proceeding is a proceeding whereby a covered individual is subject to removal from the United States.
yes. I'm sorry, I must have misunderstood you. Yes, it would cover the representation, but I think that there has to be a nexus to Maryland. So if he was a resident here, but he had moved out there, 5 years later, I think that he's on his own with out there. But if he's traveling out there and gets picked up out there, then the representation would be coordinated through a PD with another organization out there.
And then on the last page, page 6, there's this long section up at the top of the page about a local organization that enacts a program similar to this. If they do that, then there's no state support. They're going to have to pay for the support themselves. I guess my question is, why would a local jurisdiction enact a program if the state's paying for the representation? Why would a local jurisdiction enact a program to pay for representation when it would merely mean that their taxpayers were going to pay for it and the state wasn't going to pay it anymore? Why would
I think we're talking about the already existing programs. So the programs that exist in Baltimore City and Prince George's County should not be exempted from receiving state aid just because they've already stood up their programs. So if we have a statewide program, a local jurisdiction wouldn't need to go ahead and start their own program. I think this is directed at the already existing ones to make sure that they can afford themselves of state support.
Well, this says if a local jurisdiction enacts, present tense, enacts a program providing for a right to counsel substantially similar to this one, then the state money won't be used to pay for counsel. We're going to let the locals pay for it.
Okay, we can clean that up.
Okay. And then lastly, I need to ask the question. For years and years, the Bar Association has supported Civil Gideon, and I've supported Civil Gideon. The problem has always been money. There just isn't, we can't figure out how to pay for it. So what this bill seems to do is leapfrog illegal immigrants over Maryland citizens who can't afford to pay for representation for their civil legal cases. What is the public policy justification for telling impecunious Marylanders that we're not going to pay for your legal counsel in your divorces and things like that, where you desperately need legal counsel, but instead we're going to take money and we're going to use it for counsel for illegal immigrants?
So two things, and that's a very good question and a very valid policy discussion that we can have. First of all, as you know, tomorrow we're going to hear another bill that I have introduced that would afford representation in landlord-tenant matters. So that, that's obviously only a slice of the Civil Gideon that you're referring to, but I believe it's a very important slice. Second, I think the stakes here rise to the level of someone losing their liberty. We are detaining people in jails, in prisons, in detention centers where people who have, committed some very, very serious crimes are there. And we have locked people away from their families. They have lost all liberty. And the stakes are high and extremely high. And so while I agree, I would like to provide civil legal services to all Marylanders, I think that the stakes here are so high that they deserve consideration.
Okay, thank you for your answers.
All right, Senator West, all done, all clear? Okay, good. We now have Senator Castley and then Senator Bailey. Senator Castley, you're up.
Thank you, Mr. Chairman. I just kind of continue with the line of questioning that in dialogue between Senator Hedelman and Senator West. And I'm troubled because certainly people losing their children and their property would question whether that doesn't rise to a pretty high level as well. But let me, we've in the last just 24 hours, we've heard testimony on, we just had a bill that said Montgomery County, and the testimony there was they don't have enough cops to be able to keep speeders from going 500 miles an hour on their county throughway. We've got that, we had a bill yesterday for the money for the disadvantaged, to raise $6 million for the disadvantaged folks in Maryland for their legal services. We're going to tax a fee onto all Marylanders whose lives are screwed up enough that they have to go into the Maryland courts to help fix their lives up. We're going to hit them with another tax so that in an amount that will basically offset what we're going to try to provide here immediately to people who are facing federal charges. We don't have, you're saying the money for the tenants, so that'll be an endless stream. I suspect that'll go, basically, that'll be absolutely fascinating, see how big that one can get. And then we just heard of building enough school bus seats, so we gotta regulate that because people aren't spending enough money on school buses, obviously. But I guess my first question is to Judge Dornell. Can you just explain to us, because we don't do federal immigration law at all. We don't provide facilities. We don't do anything with that. So your court was in, where is that? Where's your court? Well, I know you're retired, but where was your court located? If you can unmute, please, federal or Judge Dornell. Thank you.
Thank you, Senator. My court was located in Baltimore, Maryland.
In Baltimore. And so does that just cover like Baltimore City, or is that a regional court? How's that work?
No. It's regional. We heard
So
cases from all over the state.
All over this state? Is it restricted to state borders, or is it just more a federal region, or
Maryland, state of Maryland.
It doesn't go over to Delta, Pennsylvania. It doesn't go straightly across the line. It's restricted to.
At certain points, we did hear cases out of Pennsylvania, but at the time I retired, we were just hearing cases out of the state of Maryland.
Okay. Well, and thank you for that, Judge. I guess my next question is for Mr. DeWolf, and I'm curious as to why this would not be. You said that the Maryland State Office of Public Defender would be appropriate, but there is a federal Office of Public Defender, right?
There is, yes.
And why would it not be appropriate that this matter would go through the federal OPD instead of the state OPD?
Well, I can say, when I was speaking with the Attorney General about this, we were able to point out that we have both the infrastructure and the subject matter expertise in our office because of Padilla versus Kentucky. I'm not sure that the federal public defenders gets involved in immigration. I can't say for sure, but I'm not sure they get involved in immigration issues.
Well, they would mostly be paneling this stuff out, right? You're just going to panel them out, right? You know.
Well, I think the point was that a lot of these, by the way, individuals are legal residents. They're not all illegal. A lot of them are legal green card holders. But we represent them in criminal court to the extent that we give them advice.
No, I understand that you represent a criminal court because they're in a court that's established and paid for by the law, under the laws in the Constitution of the state of Maryland. And we
Correct.
fund
Yeah,
those
that's
courts,
right.
And it's our cops that arrested them, and it's our judges that are hearing the case, and it's our prison guards who are going to detain them if they get detained. So I understand completely under those circumstances, but this is a federal law. You wouldn't normally provide a defense for somebody who's been charged with a violation of federal law in the federal courthouse, right?
That's correct. That's correct.
Right. That goes to there's your mirror image. You're a state OPD. We have federal OPD, and the federal OPD defends these folks on federal charges. And so I'm just wondering, this is basically another federal hearing. Why would we not just have let the federal OPD do this, because it's basically paneling people out anyway, and the same lawyers that you'll panel out to, they'll panel out to, only they'll do it under the auspices of their responsibilities to provide representation in federal matters.
So the federal public defender, they only do federal criminal cases. I just asked him if he does.
Well, until now, our Maryland State Public Defender pretty much only did state criminal cases, but we're kind of expanding that. But why would this not be a matter to take before our, what do we have, 8 representatives in the Congress, whatever we've got? Why is this not a matter to take before them? And it's clearly a federal matter, and we're stepping in and providing legal representation in their area. It's kind of like them saying, we're going to set up a new OPD that's going to parallel Mr. DeWolf's office, and we're going to provide public defenders for state court hearings.
Senator Cassidy, I think the testimony in the bill was that there were about 600 individuals or 400 individuals per year that would be eligible for this service. Of those 400 individuals, I would venture to say that we've represented most of them, if not all of them, in criminal court. And because we have an immigration division that is able to give advice on the criminal consequences. We are familiar with the individual and with the community organizations like Care Coalition to which these cases could be referred. The federal office would not be the same. These are by and large our clients.
Okay. When you screen these folks, if I said I'm a Maryland resident, what do you do to verify that, and what does that mean to you? I'm an eligible. I go to you and I say I'm facing a hearing, either in criminal or civil matters or deportation, and I say to your office, A, I show you I have no income, I'm broke as they can be, and B, I say I'm a resident. Then what does that mean to you when I say I'm a resident?
Well, if you recall, Senator, about 2 years ago, the eligibility for OPD was transferred to the commissioners. So to answer your question, what they would do is they would do the intake of the individual. There are certain databases that they could check to see whether or not the person has a criminal record and whether or not they have a residence. They also check with the comptroller's office to determine whether or not there's a history of some income during the past year.
Well, I got that, but assuming that I'm really not in your database because I haven't been here that long, but I tell you I've been around for a while, and I've probably been working under the table maybe. What does it mean to you when I say, are your commissioners, you're telling me that Maryland state commissioners will now screen these people for residency? Is that what's going to happen under this bill?
They screen for eligibility on income. I'm not sure. There are several databases that they have access to that we don't even have access to.
I'm sorry, they being who? Who's they?
Commissioners.
Right. So are these cases going to go before the commissioners to determine eligibility?
For public defender representation.
For public defender?
Yes.
For these immigration cases?
Not for immigration, but
yeah, that's what I'm asking. I understand you've come before us many times on the other stuff. I got the Maryland state criminal stuff. I'm looking just at this one right now. Thanks.
Yeah, I don't. Maybe Mr. Lopez could answer that question, but I don't know. Post the completion of the criminal case, we don't represent them currently represent them in immigration court. So there is no process for eligibility.
And while certainly some of these folks will be coming from a criminal prosecution, now, I mean, there's got to be a fair number of them that would not have just come out of criminal court subject to a prosecution. Their INS has got them, or whatever, ICE has got them for something else. So, but how would you're the guy your office is going to be paneling these out? How do you determine that Bob is eligible, either both financially eligible, and that I am a quote resident, and what does that mean to you?
Well, the financial eligibility has already been done. That's been done by the commissioner. But I'm going to defer to Senator Hedelman because I think she can answer the second part.
That was only if you had me on criminal representation. If I had not already been picked on criminal representation, represented by your office on a criminal matter, then you would not have had me in your system. I'm coming to you because I was the guy cutting the tree down in Montgomery County, and the big bad ICE guys came up and got me. I did nothing wrong. I'm the lady they talked about. These are all the cases we've heard. The lady who was just minding her own business, the guy who's just got the traffic ticket. These are the cases we're talking about. I should not be, I'm probably not in your system at all. But now ICE comes and gets me. How do you determine my eligibility, and what's resident mean?
I'm going to defer to Senator Hedelman and perhaps Mr. Lopez for that.
Thank you. And actually, I'm going to respond, and then I'm going to bounce it over to Corey, because she has the experience of having seen this work in other communities, or to Eric also. But so this bill obviously sets up a new infrastructure, and I think that we'll need to put in place those links between the public defender's office and CARE and the other resources in the community that they will be doing the referring to. So those mechanisms need to be there. You're right, but we need to build them.
And Senator West hinted this a little bit. What do we mean by a resident? What's a resident mean anyway? Because it means, for political purposes, can I run in my district? It means one thing. For qualifying for state financial assistance, it means another thing. For getting a driver's license, for everything is a little bit different on what's a resident. And I'm just trying to find out what we mean by a resident, and how do I become a resident? Because now I got ICE on me, and I want your help, and I'm telling you I'm a resident. So how do we do that?
Well, I mean, as we know, many people who are undocumented pay taxes. So I think, that would certainly be one area that we would look and, but I think that's something that we could probably define in the bill.
Yeah, because I'll just, the idea that these folks who've been living in Maryland for 10, 15, 20 years, they're taxpayers, they can show you their high school diplomas, their kids' high school diplomas, they've been working someplace for the last 20 years. A lot of us don't have much of this isn't as egregious. They were not convicted of a crime. They were the guy who was picked up because he was cutting trees. So that's one group of people. The other group of people is, I'm a resident because I just came into one of the 50 states, but you got free lawyers. So I am your resident. And I've got 5 buddies sitting in Silver Spring who are, swear to God, I've been shacking up with them for the last 3 months, if that's going to get me a free lawyer. And so how do we avoid becoming the de facto provider, taxpayers around become the de facto provider of free legal counsel for every INS hearing across the country, when all it takes becoming a resident is that a couple of buddies somewhere in Maryland say, oh yeah, he was sleeping here for a month or two. Great guy. If that's what it's going to take. So that's just sort of practical concerns I have that I think we really need to fill this out, because a lot of us do have some bit of empathy for sympathy for those folks, some of the hard cases you described. On the other hand, we don't have any desire to at all hit the MS-13 people who I can read you 20 cases if you like them of folks who came out of El Salvador or whatever, came up here to kill people and rape and pillage. And then they got picked up while they were in their sprees, and then they were picked up by ICE, and now we're supposed to pay for their deportation hearing. And I'm like, yeah, right. I got people who need lawyers for divorce cases and custody cases, and they're losing their real estate, their real property cases. They're about to be evicted from their homes, or the state's gonna sell their property for non-payment of taxes. There's a lot of stuff out there that's really tough, that just totally destroys people's lives. And there's an immense need, and we can cherry pick this out and feel good about the cherry picking. But in the end, we just can't do all of this, and we're gonna have to prioritize and honestly prioritize, because we can choose to ignore the people who aren't politically popular right now, but they are little old folks who are just getting screwed over by this system. So anyway, thank you, appreciate it.
Thank you.
All right, thank you, Senator Castley. We will now turn to Senator Bailey.
Thank you, Mr. Chairman. So my question, and I'm sorry I was gone for a few minutes, but my question has to deal with the amendment that you spoke of to the sponsor of the bill. So right now, the way it has to do, when we talk about legal rights and we talk about process and we talk about police officers and their lawful duty, currently if a civil case is filed against an officer of the state, the Attorney General's office represents the officer and deals with the associated cost of everything engaged and involved, unless there's gross negligence. But the civil process always comes after the criminal process. So what I wanted to make sure of is, if way the bill is worded, and I didn't see the amendment, when we deal with criminal comes first, if we give these people in fact to the Attorney General's office and they represent them, does the Attorney General representing this illegal immigrant in the criminal proceeding, is their office then conflicted so they could no longer represent the police officer if there is a civil action for them doing their lawful legal duty?
So I'm a little confused, because it wouldn't be the Office of the Attorney General first. And second of all, this is just dealing with the deportation proceedings and anything affiliated with that, not if, and tell me if I misunderstood, but it sounds like you were talking about representing them if they were had some complaint against the law enforcement officer. That would not be covered under this bill.
So
just in the deportation proceedings.
Are you still utilizing the Attorney General's office at all? And
No.
and I was stepped away for a minute.
No.
Okay. All right. And that's an answer to my question. Thank you.
Thank you.
Okay, excellent. Looking around the room, are there any further questions for the panel or for Senator Heddleman? All right, seeing none, thank you, Senator Heddleman. That concludes the testimony for Senate Bill 317. We'll now move on to your second bill of the day, Senate Bill 75. Senator Heddleman.
Thank you very much, Mr. Chairman. I am here on Senate Bill 75. This is, and I am looking around, and I think, unfortunately, one of my main witnesses is not able to join us, thinking that our testimony was going to, that her testimony would be required earlier. So unfortunately, she's not able to join us, but her written testimony is has been introduced. So I'm introducing this bill in response to a tragedy that befell one of my constituents. And this was the Friedman family, who lost a family member in 2019 because of the poor driving of an elderly motorist. And I do commend you to that testimony. Senate Bill 75 would implement a requirement that drivers age 85 and above should renew their driver's licenses in person for each renewal. Right now, the Motor Vehicle Administration's most recent stats on crashes involving drivers age 65 or older shows that between 2015 and 2019, the total number of crashes went up by 24%. And while the number of fatal crashes remained the same, the number of injuries went up 19%. Several states have implemented measures to try to ensure that older drivers have the ability to drive safely. And for example, a dozen states require more frequent license renewal for older drivers. In Maryland, older drivers aren't required to renew their licenses more frequently. Like everyone else, they renew their licenses every 8 years and have the option of renewing by mail every other renewal. And with regard to vision testing, everyone over 40 years old has to pass a vision test or provide proof when renewing via mail. One measure that some states have implemented to ensure the ability to drive is not diminished with age is a requirement that older drivers renew in person for each renewal, removing that mail-in option. And there are 13 states that have this requirement, including Virginia, California, Texas, Georgia, and Illinois. Research has shown that in-person requirement is effective. The Journal of the American Medical Association found in a 2004 study that of these different measures, in-person renewal requirements, more frequent renewals, and vision tests and road tests, that out of in-person renewal requirements, more frequent renewals, vision tests, and road tests, the in-person renewal requirement actually has an impact on reducing elderly driver fatalities, and it reduced fatalities by 17%. The study didn't identify the reasons why in-person license renewal is related to a reduced fatality rate, but the authors had a couple of theories, one of which was that potentially unsafe older drivers may be less likely to apply for a license when facing having to go into the MVA to do it. That is, they pulled themselves out of the process and they self-selected not to go in. This bill was introduced in the House last year and it passed 130 to nothing. And unfortunately, it wasn't considered by this committee because we adjourned early. Respectfully, I ask for your favorable consideration of Senate Bill 75. Thank you very much. I'll turn it over to my panel. I think I see Dr. Simmet. Yeah.
All right, thank you, Senator Heddleman. So I now turn to your panel and we'll have Mr. Simmet, Tyler.
Hi there. My name is Tyler Simmet. I'm an internal medicine and geriatrician in Baltimore, Maryland, and I work for osteopathic medical schools during the day, but I'm speaking as an individual. And I've got an easy job today. My job is to convince you that as you age, you get older, and that means something. And what that means is you're going to lose skills. And driving is one of the critical skills that's going to be lost. As a doctor, I can tell you that 25 to 35 years of age is the physiological peak of life, where you can probably drive around the Beltway at 90 miles an hour on a motorcycle on one, we won't go there. But after 35 years of age, our bodies change, our abilities change, and so do the risks that these abilities create for ourselves and those we come in contact with. When we look at lifespan, we look at a life being 0 to 95. the body's built to last 95 years of age. But between the ages of 50 and 70, most people will lose about 1/3 of their muscle strength. And between 70 and 80 years of age, they'll lose another 30% of their muscle mass and their strength. The loss of muscle mass will slow your reflexes, decrease your visual acuity, and all of these increase driving risk. We know that by 45 years of age, people lose the ability for a 30-second stand test. They can't stand on their non-dominant leg for 30 seconds, and they become more unilateral in their functioning. By 55 years of age, the hip flexors weaken, and the majority of adults will lose the ability to swing their hips in a flexed manner. So you can't duck walk. It's possible to stave off some of these aging changes with exercise, with practice, with focus until you hit 80. After 80, it's going to be an issue. And we know with these functional deficiencies, people start to hide their weaknesses and their deficiencies because they're losing independence. And we know that after 3 years of having lost muscle strength or use, it's irreversible and you can't get those back. So it would lead from this information that we want to assess how skills are lost. But as Senator Hedelman talked about, the studies show that just assessing somebody is enough to reveal weaknesses, and that if people are going to have to expose their weaknesses, they'd rather not get assessed. Because in rehab, we talk about the 30-second stand, we talk about duck walking, we talk about the ability to walk 20 feet, which is probably less than you have to walk to getting from your car to getting to the license renewal. So we do think that just having it happen in person will be sufficient assessment to weed out the people who can't do it. So the bill by Senator Hedelman addresses the issues in a way that provides the control to the person requesting the privilege of driving. It should be enough. I'm thankful to Senator Hedelman for addressing the issue, and I hope the medical information is useful, and I'm happy to answer any questions that you have. So I urge a favorable vote on this bill. Thank you.
I just want to add the witness who wasn't able to come, her name is Bracha Polikoff, and she testified herself. She is actually a social worker, and her mom was killed because an older driver was very confused and ran into her, and she died. But she also includes, there are 2 pieces of testimony to her experience, and then a colleague from LifeBridge Health, who is an occupational therapist, who talks about working with older adults. So I just commend your to view the testimony. Thank you.
All right, thank you, Senator Hedelman. And seeing no questions, Senator West has a question. We almost got out of there.
Yeah.
There you go.
Okay. This is just, my father had Alzheimer's, and late in his life, he most emphatically did not want to give up his car. But through help working with his doctor, they withdrew his license and required him to go down have a new test. It didn't work out real well for him. So I certainly understand the wisdom behind this bill. I will say to the doctor that while he was testifying, I got up and I stood on one leg, on each of my one legs. And even though I'm over 45 years old, I was able to do it. And I think I did the duck walk. I tried to swing a hula hoop, even though I don't have a hula hoop. And I did that successfully too. So it's not everybody over 45 or 55 who has these problems.
It is not. And again, it's after 80 that it becomes irreversible. Between 70 and 80, people can stave it off with exercise, yoga, balance practice. But after 80, once you've lost more than 30% of your muscle mass and you start getting the fluid replacing the muscle mass so you have the same weight but less muscle, it becomes much harder to compensate and the balance becomes much more difficult to maintain.
Thanks. 10 years from now, I'll get back to you and we'll see how I do. Thanks.
Mr. Chair.
Senator Carter, you're up next.
Thanks. I'm so sorry to prolong. I'm anxious as well as the committee to get through this, but I did feel, first of all, Dr. Sinet, thank you for ruining my entire day and the rest of my life with that terrible news. I also believe I can stand on one leg, but I wanted to ask you, do you testify in DUI cases?
I have not in the past.
I'm just suggesting because, by saying that now I know that anybody that I represent over 40 they're not expected to be able to perform these tests. But Senator Hellman, I appreciate the sentiment behind the bill. There's a couple things. I just don't know that showing up in person really does anything. I mean, it's not requiring that they take any more tests or anything, right? It's just saying show up in person.
They do have to take a vision test. And I agree with you. At first I was like, how does this work as a deterrent? But there's actually, and I'm happy to send you this journal article that the Journal of American Medicine talks about, that this is a statistically significant deterrent to people to people withdrawing themselves from the process, not going in, kind of saying, I don't want to have to go in because I might not be able to succeed, and so I'm not going to.
Okay, I was just wondering, because I was thinking, like, what would stop a daughter or son from driving their parent to the place and dropping them off and say, go in and get your thing renewed? Because I don't want you to be without a license for emergencies or whatever, you know?
Nothing. Right?
But if you come to my office, I would make you walk 20 feet. And if you can't walk 20 feet, I'd say you're not eligible or competent to do it. Having them walk 40 feet to get from the parking lot to the renewal may be a deterrent because they know they can't do it. And people will walk 5 steps to their car, but not 20 feet to renew their license.
They do have to take a vision test too.
Okay, thank you.
All right, excellent. Sorry, I've got people in the room here, so I'm trying to keep a mask on. So Senator Carter, you're good to go?
Next.
Okay, great. So then with that, no more questioning. That concludes the testimony for Senate Bill 75. All right, so then we'll move on to Senate Bill 20. Senator Carter, floor is yours.
Thank you, Chairman Smith and members of our committee. I promise that this is a simple and straightforward bill, and it should be short. It's to the point. To understand this bill, one is only to look at the fiscal note, and it lays out very clearly what the bill does. It is simply one more step that we've taken in the past towards decriminalizing nonviolent motor vehicle offenses that are related to canceled, revoked, and suspended licenses. The bill seeks to eliminate jail sentences of 2 months, making no jail time, as well as eliminating or reducing the number of points that a person can receive from 12 to 3. The bill doesn't change the fine of $500 affiliated with this. What is the reason or impetus behind why we need the bill? Because in the current form of having the 2-month sentence, that requires officers to arrest, have people held, see a commissioner, potentially be held, see a judge, and also because any incarcerable offense is a must appear in court, which means also that they have to go through the whole process, and then they also have to stand for a district court trial. This would remove all of that. And we passed a version of this bill last year unanimously. And I believe that there is a possibility that we're working on an amendment that would actually make this bill exactly like last year's bill that we passed. I'm not sure what happened with drafting, why it wasn't, but the aspect of last year's bill that was added to this was the concept that there would not be suspensions, revocations, or cancellations if the underlying reason was because of failure to pay a fine, like from a traffic ticket or something. So that was just another step. And so I'll defer to the committee's wisdom, but I'm happy to pass the bill as is, or actually add to it and make it better, as I think it was last year when it had that other component. I'm joined by a representative of the state's attorney's office, as well as the Job Opportunities Task Force, and happy to answer any questions. Thank you.
All right, excellent. Thank you, Senator Carter. So first we have Mr. Ahmad, you're up.
Sorry. Good afternoon, everybody. My name is Yusuf Ahmad. I'm the Director of Legislative Affairs for the Baltimore City State's Attorney's Office. As the Senator mentioned, a version of this did pass last year. I'll try to speak to that as best as I can. Our prosecutors have handled thousands of cases, thousands of traffic cases. Some of these prosecutions dealt with serious offenses that put the health and lives of pedestrians at risk. This bill doesn't deal with these types of offenses. It simply seeks to decriminalize offenses which often come about as a result of poverty. Pursuant to 16-301C, D, and E, an individual whose license is canceled, suspended, or revoked faces a penalty of 60 days in jail and a $500 fine for showing their license to an officer. Our prosecutors have shared many anecdotes in which people charged under this statute were unaware that showing an officer a canceled, suspended, or revoked license was against the law. Upon a license being canceled, suspended, or revoked, the licensee is supposed to surrender their license to the MVA. It's sent to them in a letter from the MVA. However, many of these people who face suspension suffer from unstable living addresses. They never actually receive these notices, or their license is oftentimes their only form of identification, and they can't fathom parting with that identification as they need it as a means to survive. It's unsurprising that many of these individuals charged with this crime have common ignorance of its criminality, but are also impoverished. As to the amendments that Senator Carter was talking about, last year's version that moved out of this committee also contained a clause about default judgments. Currently under 16-303C, an individual who drives on a license which is suspended due to the failure to pay a civil judgment faces a maximum penalty of 1 year in jail and a $1,000 fine. The added amendment would simply move that clause from a 16-303C to a 16-303H, just making it a maximum penalty of $500 and no jail time. It's an important step towards the decriminalization of poverty. In our experience in Baltimore City, at least one case every docket charged a person for driving on a suspended license where the suspension was due to the failure to pay a civil judgment. One gentleman in his 50s told us, and his paperwork confirmed, that he had been paying off a $10,000 civil judgment for over 10 years. But while paying that debt, he had been ticketed multiple times under the punishment under 16-303C, incurring thousands of dollars worth of court fines and spending multiple days in jail. Despite him paying down his civil judgment over 10 years, the accumulation of court fines, he still owed in excess of over $10,000. The criminalization of all of the above conduct does not further the goals of criminal sentencing. It doesn't make our community safer. We try in our office to prioritize justice over convictions. All that the current penalties do is push impoverished people further into debt and poverty. Can sometimes force people to lose their jobs and homes and spend time in jail. Supporting and enacting SB 20 in any form would eliminate the possibility of incarceration for these offenses, and we would support any version that comes out of this committee or that this committee is willing to move on. Thank you very much for your time and consideration.
All right, thank you very much, Mr. Ahmad. Next, we'll have Mr. Dews. Chris, you're up.
Good afternoon, members of the committee. My name is Christopher Dews, and I'm a policy advocate for the Job Opportunities Task Force. Our mission, as you may well know, is to help low-wage workers advance to higher-wage jobs. One of the ways that we do that is through policy advocacy, and as Yusuf has already mentioned, very well spoken before me, we're also interested in decriminalizing poverty for those who are poor. So what we see with this bill, of course, you already know the rules, 60 days of possible incarceration and a $500 fine if you display a license. Now, Senator Carter and Delegate Moon have already done tremendous work around these issues of reducing or eliminating incarceration for these types of penalties. And so we just want to take that next step and get rid of it for displaying a driver's license that is currently invalid. What we see with our constituents is that people have paid off child support that may have gotten their license suspended in the first place, but the reinstatement had not happened yet, and then they get stopped. Or what we find out is that people don't even know that their license has been suspended or is revoked because paperwork, as Yusuf had already mentioned, paperwork was sent to a location that they no longer reside at, or they're generally housing unstable. And so the idea of somebody being incarcerated for just displaying a license is a little rough. And so for those reasons, we only would request a favorable report with an amendment to reduce the fine down to $50 instead of $500. We think that number is a little egregious during this pandemic times. And so for those reasons, we urge a favorable with amendments report. And we're willing to work with the sponsor to make that happen. Thank you for your time.
Thank you, Mr. Dews. Appreciate it. Next, we'll move on to Mr. Sweeney. you're up next.
Good afternoon, members of the committee. Thank you very much for the opportunity to testify today. My name is Chris Sweeney. I'm a staff attorney at Maryland Volunteer Lawyer Service, and I manage our workforce development project where I focus on removing barriers to employment. Through my practice, I serve many people who are seeking to re-enter the workforce. Many of them have debts that are holding them back from basic things like rent or buying a vehicle. Many have criminal cases on their record that they're seeking to expunge. And I wanted to address this bill in particular because I believe it would open up many opportunities for Marylanders who are seeking to better themselves in their communities but have been held back by a criminal record. I wanted to talk specifically about removing incarceration as a penalty for these charges. As you'll know, traffic offenses that carry the possibility of incarceration are treated just the same as any other crime under Maryland's expungement law. And a conviction for even the smallest offense often blocks a person from expungement entirely. So I wanted to tell you a story about a client of mine whose story is not at all uncommon among the people I've served. His name was James, and I met him through Civic Works, where he was training for the solar energy field. James had spent a few years in and out of some low-paying jobs, and he had been steadily falling into debt. And after a couple of common traffic infractions that resulted in fines he couldn't pay, he eventually had his driver's license suspended. But not having enough money to pay for those fines and not being able to get to work without driving, he had to make that tough choice to risk driving to work. And he ended up with a conviction for a suspended license. Now, of course, James did break the law in this instance, but now he was in job training and seeking to turn his life around, looking for a long-term career. And I had to be the one to inform him that not only could he not expunge the suspended license charge, but it also would block a misdemeanor theft charge from nearly a decade ago from being expunged as well. So these are the sorts of unfair situations that these incarceration penalties can put on people who get convicted of driving or displaying a suspended license. So reducing the penalty to just a fine would allow many people to move forward with their lives. And for that reason, I respectfully request a favorable report on this bill. Thank you very much.
All right, thank you very much, Mr. Sweeney. And with that, I think that rounds out the panel. Senator Carter, are there any questions from committee? Okay, Senator Castley has a question.
Thank you. So I'm just trying to make my way through this, and it's back and forth. You add, you get, you give, you take, you give, you take, and it's kind of tough. Can you the last page? Somebody who's just good on the bill, just kind of take me through explain the last page of this bill for me. It talks about being assessed 3 points, 12 points. This is just for anybody that's good on this.
So, Senator Castley, can you hear me?
Yes, I got you.
Pulled up the bill. Of course, I just lost it again when I came back on the screen. Okay, so I was going by the chart. So the current law is 12 points under the bill 3. The current law is $500 under the bill $500. The current law is 2 months potential incarceration. The bill is no incarceration. So I'll
talk to you offline, Joe.
Pretty straightforward, isn't it?
Yeah, I guess. I mean, I think I'm with you on this. I just want to iron out a few, make sure I'm thinking straight through it, but I don't really have major issues with it.
Oh, I'm sorry. I was looking at the fiscal note. All right. About it. I said, I just realized I pulled up the fiscal note. No wonder I didn't know what you were talking about.
No, I'll get with you offline. We can talk through it.
Okay.
Thanks.
Fantastic. All right. Further questions from the committee? All right, seeing none, that will end the hearing for Senate Bill 20. We'll now move on to our final bill of the day, Senator Wallstraker, to Senate Bill 293. Mr. Vice Chair, you're up.
Thank you, Mr. Chairman. Senate Bill 293 is a bill that we've heard before and has passed the House, and we just ran out of time last year. But I wanted to kind of press reset on the bill and tell you why it's so important. This bill deals with vulnerable road users. In previous hearings on the bill, we've kind of talked a lot about bicyclists, but bicyclists aren't the only folks who are protected in this bill. This protects officers on the side of the road, assisting folks whose cars have broken down. It includes EMS workers. It includes pedestrians on a sidewalk. It includes kids who run out into the street to grab a ball. It includes the Amish in Senator Bailey's district. It includes all sorts of folks who are vulnerable on our roads, and it makes sure that we protect them appropriately. So here's what the bill does, because I think there's been some confusion in years past. The main part of the bill requires folks who are cited for hurting or killing a vulnerable road user to appear in court. And the reason that is critical is because it allows the judge to help course correct that person's behavior, including requiring a driver education. And that's important because as our law is currently structured, and this is the problem we're trying to solve, as the law is currently structured, you're either charged with a very serious crime of killing or maiming someone, or you just get a ticket and you can pay the ticket without ever having to show up in court. And we're trying to find a way for folks who have done something serious and violated the rights of someone who is very vulnerable to make sure that they get into court and the judge has the opportunity to say what they did wrong and to make sure they are provided with the opportunity to make sure it doesn't happen again.
Oh, man.
Here's what the bill does not do, because I want to make sure that we eliminate some of the confusion that we've seen in previous years. This bill doesn't have a mens rea change. It doesn't kind of deal with this issue of recklessness or negligence that we've been struggling with in other legislation. This bill doesn't speak to that at all and is not trying to create a new midpoint mens rea. It doesn't interact with any of the other legislation that we've talked about this year. It's unrelated to those bills and is in a different part of our statute than those bills. And finally, last year, there was a section of this bill that was confusing to folks related to careless and distracted driving. That part was unnecessary to the legislation, not core to what I'm trying to do or the advocates who support this bill are trying to do. And so we took that language out. In doing so, we've been able to garner the support of MDOT and MVA. And with that, Mr. Chairman, I ask for a favorable report.
Thank you, Mr. Vice Chair, and thank you for all the work on this bill. Definitely a lot of progress since last session. We'll start off with Mr. Wilborn. Is that right? Mr. Wilborn, you are up. I don't see that. So then we're going to move on to Ms. Rund. Is Ms. Rund here? All right, here you go. We're going to ask to unmute you, and if you just toggle over to your screen and hit the unmute button. There you go.
Can you hear me okay?
You can, yes.
Sorry about that, just a little technical difficulty there. Thank you very much for allowing me to testify on Senate Bill 293. I am the Baltimore County Fire Chief, and I reside over 3,000 career and volunteer personnel. Currently, we responded to 12,228 incidents over the last year. During those incidents, we encounter many times where we have near-miss incidents where drivers are not paying attention and they come very close. So we have to set up multiple units to make sure we protect our personnel. Operations on the roadways are very high risk and they're high frequency incidents. And often we deal with distracted driving and drivers under the influence along the roadway, bad weather conditions, etc. Every year there are reports of firefighters, EMS workers, and recently, even within the last month, state police officers struck along the roadway, tow truck drivers as well. Along these times, these incidents happen to possibly even strike and kill these personnel. I have a personal experience of a person that I worked with in Howard County who was struck and killed on the highway on Route 32 years ago. And the driver that did that was simply fined $310 for punishment for driving, negligent driving and speeding. And that was it. Unfortunately, the loss of that life was a public servant, and the family is forever lost. So it is our hope that Senate Bill 293 is passed. It will help act as a deterrent to driving while distracted and help reinforce the move over laws that we currently have in place today. It is for these reasons that I ask respectfully for a favorable report on Senate Bill 293. Thank you, sir.
Thank you very much. All right. Next we have Mr. Samarero.
Thank you, Chairman Smith, Vice Chairman Walt Stryker, distinguished members of the Judicial Proceedings Committee. My name is Nigel Samaru, and on behalf of myself and Bike Maryland, I would like to thank you for allowing me to address you today regarding what I feel to be very important and needed legislation. On July 20th of 2017 in Columbia, Maryland, I decided to do a quick 20-mile bike ride when I was T-boned by someone driving a minivan, resulting in a broken neck and paralysis on my right side. I was transported to shock trauma where I underwent surgery. I then learned from the police report that the person driving that day saw me approaching in the opposite direction and admitted to the police that he thought he could beat me in time to make his left turn onto US 29 northbound. I've since regained the use of my right side, but I now suffer in constant 24/7 pain on the left half of my body, my right arm, hand, and shoulder. I'm left with permanent damage to my spinal cord, which requires monitoring for the remainder of my life. The driver received a ticket and a fine for this crash. To say that this has changed my life would be truly an understatement. As my pain management doctor recently said, "This really messed up your life." Truer words could not have been spoken. Currently, there is no legislation that would warrant a second look at these individuals who hurt someone through their negligent driving. I ask for your support for this needed legislation. I thank you for your time.
Thank you, Mr. Samaru. It's good to see you again. And thank you for your continued advocacy on this bill. We have next we have Mr. Corrin. John, you're up.
Okay, thank you. Thank you, Chairman Smith, Vice Chair Walt Stryker, and sponsor, and members of the committee. I'll just fill in a few additional things that have not been said. Sadly, the numbers are going the wrong way. If you separate people in vehicles from people outside of vehicles, fatalities and injuries for the group outside of vehicles is rising both nationally and here in Maryland. In the first 3 quarters of 2020, there were 100 pedestrian and bicyclists killed on Maryland roadways. The same period prior year, 96, and that's with driving way down due to COVID. So the problem we're trying to solve here is that the numbers are going the wrong way. This was the #1 recommendation out of the 2017 Maryland Bicycle Safety Task Force, which I served on, that was created by this legislature. 10 states have enacted similar statutes. We have the support, as has been said, of both SHA and MVA. We think this will be a very, very important deterrent. We think this will provide the foundation for safety campaigns that encourage drivers to have a higher duty of care when they are in the vicinity of vulnerable and lawful users or crossers of our roadways. I hope you'll support this bill. Thank you.
All right, thank you, John. So now we'll turn to the panel for questions, and I'm seeing Senator West has a question.
Thank you, Mr. Chairman. I think I finally figured out how to unmute myself after 2 weeks of hearings. I guess my concern with this bill, Senator Walt Stryker, is that it's sort of a one-size-fits-all bill. So let me give you a hypothetical. Person's driving on a street and it's nighttime and there's a drizzle going on and there is somebody on the quote highway, to use the word from your bill, who is wearing dark clothing, and as the motorist is approaching the person, the child in the back, in the baby seat in the back screams. And so there's a momentary situation where the driver looks back to check on the child and then looks forward again and doesn't have the time to stop. Under this bill, that person must appear in court, can't prepay a fine, and the driver's license shall be suspended for at least 7 days. And the fine can be up to $2,000. So that's a situation in which I think that the punishment in this bill would be draconian. So my suggestion is at least you consider in adding a provision that would say something like, the court may take the circumstances at the time of the accident into account in determining the penalty to be imposed on the motorist.
I think you and I are thinking alike, but I want to point out a portion of the bill that is a little bit hidden because it straddles 2 pages. But if you look at page 25, line 25 on page 2, and then line 1 on page 3, it indicates that the person who is doing the striking, in other words, the vehicle in your example, that the person has to be in violation of any provision of this title. In other words, a person has to do something in a wrongful way in order to be captured within the scope of this law. And so, simply turning around because there's a loud baby in the back seat or otherwise some kind of momentary lapse that is not otherwise a violation of the motor vehicle title would not come within the scope of the law. So in order to violate this, you have to have done something wrongful.
I'm not sure I understand. So in my hypothetical, you're saying that that person would not be covered by this bill, even though the motorist hit the pedestrian. This bill would not cover the motorist because what?
Because they are not in violation of any provision of this title, which is line 1 on page 3. In other words,
what is where would the title contain language which would exempt such a motorist from violation?
So the title referred to in line 1 of page 3 is the transportation article. So if you're not in violation of any other law within the transportation article, you are not subject to the penalties under this additional law. In other words,
if you're driving negligently, that would you or would you not be in violation of the transportation article?
I think that's a question that we'll have to ask counsel at some point because I'm not familiar with every portion of the transportation article. But for example, if you are speeding, let's just change the hypo to something you and I kind of.
Okay, yeah, speeding. I have no problem with that. Now, my concern is with somebody who's not speeding, who's driving, safely, and all of a sudden, out of nowhere, in the middle, the darkness, here's this person, and the car hits the person. If that's the case, I think if that's a valid defense, then I think you're leaving yourself open to an awful lot of people going to court and saying, Your Honor, I have a valid defense here. I wasn't driving too fast. I wasn't, so maybe this bill doesn't do what you wanted to do.
So don't forget, it's not a civil law. This is a criminal charge, and the prosecutor would have to be able to prove what the underlying violation is, in addition to the fact that the victim was a vulnerable road user.
So you would have to be violating the state's motor vehicle laws before this bill would apply at all.
That's correct. That's what line 1 on page 3 is referring to. But to the extent that you don't think it's clear enough, I'm happy to work with you to try to clarify that. But you have to violate an underlying law within the transportation article, and you have to cause serious injury or death to an enumerated vulnerable road user. And those
Okay.
users are delineated in the statute.
All right, I see. Maybe we can make it clearer. I think that solves my problem. You know, if the person was speeding on a dark night and hit somebody because they can't stop because they were speeding, that's one thing. But if they're driving safely and something distracts them for a moment and then they turn around and there's a person not wearing any reflective clothing in the middle of the street, that's something else again.
That's right. And just to be clear, even if the person is violating the law, if the vulnerable road user is also violating the law, that vulnerable road user is not protected under this law.
Where does that appear?
Sure. If you look at line 14.
Oh, it says lawfully.
On page 2. So if a pedestrian is jaywalking and you're speeding 20 miles per hour above the speed limit and you hit the jaywalker, you cannot be charged under this, even though you also were acting unlawfully because the pedestrian was jaywalking and not acting lawfully. And that's true not only for pedestrians, but I know sometimes there are concerns about bicyclists who are like running red lights and things like that. They're not protected either.
Okay. Well, you've certainly illuminated an element of this bill that I didn't see when I read it. So thank you very much. Maybe we can work to make it a little clearer.
Okay.
Excellent. Thank you, Senator West and Vice Chair Waltrecker. We'll now go to Senator Sidnor, who has a question.
Thank you, and I appreciate Senator West's questions as well, because I know when I first talked to some of the advocates, that was some of my concerns. So thank you for letting me know that this is just about criminal violations and not necessarily accidents. But one of the concerns that I had raised last month was that in no way do I see something like a farm tractor or farm as being a vulnerable individual. And that type of vehicle is more likely than not larger than mine. So I think you might want to go back and really think about what we are trying to protect in this definition of what a vulnerable individual is. And that's it.
Thank you, Senator Sidnor. Yeah, so I'm happy to kind of discuss the list with anyone. We wanted to make sure that vulnerable road users in rural jurisdictions are protected just as much as in urban jurisdictions. But also, I'm guessing, and I don't know, but I'm guessing the tractor was not because of the size of the vehicle that they're in, but because it's uncovered. So if you were to strike a tractor, even though your car probably weighs less than a tractor, if the guy on top of the tractor gets thrown, he's a goner. And so I think that's the idea there. Same thing why motorcyclists are included. They're also on a vehicle, but because they're going to be thrown, they may need more protection.
All right, excellent. Thank you, Senator Sidnor. Looking around the Zoom room for further questions and seeing none. Thank you, Vice Chair Walstreicher. And with that, that'll conclude the testimony for Senate Bill 293 and the hearings for the day. But we're not done yet, JPR. We have a voting list, and hopefully we can get through it with relative, not ease, but relatively quickly. It's 4:03 now. Let's get down here in 15 minutes. So let's call it 4:20. Come down to 4:20, 17 minutes. See you all in a bit. Thank you all.